And we are in the throes of Unit 9. And please remember, Unit 9 is just basic contract law, maybe not necessarily specific just to real estate. Unit 10, we're going to bring real estate into it. But the reason we need to go through Unit 9 is so we understand how a contract works. Agency agreements are examples of contracts. Our offer to purchase and contract is the contract. And again, that's where we're heading in Unit 10. So we left each other on Tuesday, talking about this idea of the offer, introducing you to the idea of the offer. Now we're going to build on this. We're going to add to it when we get to Unit 10, and we specifically have the conversation about real estate. But in basic terms, let's see. Can anybody hear me? Can you guys hear me? Okay. In basic terms, remember we talked the other day that an offer has to be presented. One of our essential elements of a valid offer is we have to have mutual assent. We have to have the meeting of the minds. And what I mean by that is the two parties have to agree to enter into the contract together. And in order for them to agree, an offer has to be presented, an offer has to be made, it has to be considered, and it eventually has to be accepted. So the offer, or don't think about buyer and seller. I fear you guys hurt yourselves when you think about buyer and seller. Your test is not going to ask you about buyer and seller. So we need to understand the roles of the people in the offer. The offer or is the giver of the offer. Please remember our ORs and EEs. The offer or is the giver of the offer. The offer E is the receiving. So you have one party making an offer to another. As the receivee, the offeree has three choices when they receive an offer. Let's rattle those off together. What are their three choices? They can accept, they can reject, or they can counter it. If they accept, they're agreeing to all of the terms. You hear my absolute word there? All of the terms exactly how they are. With acceptance, there are zero changes. I don't care how small and insignificant it may seem. Let's say, for example, I make an offer to buy your house and I want to close on June 1st. And you say, no, I can't do June 1st. Let's do June 2nd. In the big picture of the world, does the day really matter? Does one day matter? I mean, how significant is one day? But it's a change. So if you say, no, I'm good with all these terms except for the closing date, I need to close on June 2nd, then we have created a counteroffer. So with acceptance, we have complete acceptance of all the terms exactly how they are. If the offeree rejects the offer, it's dead on the table. It has been killed. And guys, there's no going back. Once it's been killed, it's killed forever, right? There is no reviving it. Once an offer is rejected, it's dead. Then we have this counteroffer. This is important. A counteroffer is a rejection. The offeree is saying, I don't agree to all of the terms. I agree to some of the terms, but not all of the terms. A counteroffer is a rejection with a but. And in a counteroffer, if we remember our introduction to our contract communication wall, we have the offer or on one side, the offeree on the other. The offer or makes the offeree considers it, the offeree counters it. And in a counteroffer, the roles reverse. The offer or becomes the offeree becomes the offer or, and now the offer or is making a brand new offer to the offeree. the roles reverse. So now the offeror's offer has been countered and they become the offeree. And as the offeree, what are their choices? They can accept it, reject it, or counter it. If they counter it, the roles reverse again. With a counter offer, with it being a rejection, there's no going back. Once you counter it or reject it, there's no going back. Now, let me ask you guys this. Let's say in this case, the offer's been countered. The offeree says, no, I reject it. I don't like the counter offer, I reject it. The offeree is never bound to anything until they accept it. So the offer's been countered, the offeree rejects it. And this person comes back and says, no, I'm sorry, don't reject it. Please don't reject it. I will accept your original offer. Can they accept the original offer once they've countered it? No, because when they countered it, they killed the original offer. That's what I'm saying. That original offer is dead on the table. They can't go back and change their mind. They can't revive it. However, could this person make a brand new offer to this person with those exact same terms? Yes. So instead of saying, oh man, I should have never countered that, I'm so sorry, I'll go back and accept your original offer. What in this case they need to say is, okay, let me make you an offer with those terms. Offeree has three choices: accept it, reject it, or counter it. Again, when we get into Unit 10, we're going to talk more about this. We're going to see the contract communication wall again. We're going to bring agents into the mix, what happens when we're involved in the picture. And then when we get to Unit 10, we're going to talk about this magic moment in time when it goes from being an offer to a contract. As buyers and sellers, real estate agents, do you think that's important to know? That moment, that exact moment in time when we're under contract, when you can call your buyers and sellers and say, congratulations, we're officially under contract. Do you think that's important? Kind of, sort of, right? So we're going to build on that. We'll talk about when that offer becomes a contract when we get to Unit 10. So this idea of the offeror, again, please see the OR, the giver of the offeree being the receivee of the offer. Guys, get your chats out. I want you to answer a question for me in the chat. Back in Unit 5, we talked about a North Carolina law. The North Carolina law that said that there are certain documents that have to be recorded in order to be enforceable. What is the North Carolina law that says certain documents have to be recorded in order to be enforceable? And if you don't remember, please tell me you don't remember. I'd like to hear from everybody, though. Make sure we've had our first shot of coffee this morning. So we introduced you to a law, a North Carolina law specific, that says there's certain documents that have to be recorded. And the whole reason we record is so that they are enforceable. Need another shot of coffee. Everybody in? So back in Unit 5, we introduced you guys to the Connor Act, the North Carolina Connor Act. Remember Connor, our old buddy Connor? Connor says there's certain documents that we have to record. We must record. For example, Connor is the one that says that the deed has to be recorded. Recording the deed doesn't affect the validity of it. The only thing that recording does is makes that deed enforceable against third parties. Why do we record it? Why do we record anything? So it's enforceable. Everybody with me so far? We good, Connor? Okay. There's another law. Another law or act is called the Statute of Frauds. The Statute of Frauds says that there are documents that have to be in writing to be enforceable. Connor says it has to be recorded. Statute of fraud says it has to be in writing. I would put those on a flashcard. On the test, a very common mistake is to confuse Connor and the statute of frauds. Connor is about recording. Statute of fraud says it has to be in writing. Can we see that the two parallel each other often? I mean, I can't record something that's not in writing, right? So the two run side by side, but they do two different things. Connor says it's got to be recorded to be enforceable. Statute of fraud says it has to be in writing. So go back, flip back in your book with me real quick to page 257. And on 257, we looked at the essential elements of a valid contract. Again, when the judge is trying to determine the validity of a contract, he's looking for these essential elements. Do we have legally competent parties? Do we have mutual assent, legality of object and consideration? On page 257, do we see anything at all about being in writing when we look at those essential elements? Is that what we see? No, because remember, the judge, when determining the validity of a contract, the judge is looking for these four things. It's the statute of frauds that steps in and requires it to be in writing. So now that we know the statute of frauds, do our real estate contracts have to be in writing? They need to be in writing? Yes, but it's not because it's an essential element of the contract. Our real estate contracts have to be in writing because of the statute of frauds. So statute of frauds says there's certain documents that have to be in writing. And this applies to when we're conveying real estate, real property. So the sales contract is an agreement to convey real property. Everybody have that written down? I suggest a flashcard on that. Connor's about recording. Statute of frauds is about in writing. The whole point of the statute of frauds, by the way, the whole reason that we require things to be in writing, we're trying to prevent forgery, or the court is trying to prevent forgery, dishonesty. If you've ever bought a house, or when you start working with buyers and sellers and you go to the attorney's office for closing, one thing the attorney is going to request from the buyers is their driver's license. Why does the attorney want to see their driver's license? One, we want to get their full legal name, right? What's the best place to get somebody's full legal name? Look at their driver's license. But two, doesn't the attorney want to verify they are who they say they are? They're trying to prevent forgery. So Connor says we record, statute of fraud says we put it in writing. There's another rule regarding in writing. This is something called the parole evidence rule. And what the parole evidence rule says, the final written agreement is going to win every single time. The final written agreement will prevail over any previous negotiated terms. May they be in writing or orally. Parole evidence rule says the final written word in the contract wins. So if we have previous negotiations, if we verbally agree to something, or maybe we text back and forth and we agree to it, if that agreement doesn't make it in the final contract, it doesn't count. It doesn't matter. For example, let's say you are the listing agent. We'll make you the listing agent. And you're getting ready to list this property for sale, and you're going through the home with the seller, your little checklist, and you get to the kitchen and you ask the seller, are you willing to leave the refrigerator? And you're going to ask the seller that because you know practically every buyer is going to ask you, does the fridge stay? Does the fridge stay? Does the fridge stay? So you're going to have this conversation up front. Seller says, yeah, I'm going to leave the refrigerator. You as the listing agent advertise in your listing, refrigerator to remain with acceptable offer. You put it in your promotions. You put it in your advertising. You have an interested buyer that is about to make an offer. The buyer's agent calls you and says, we're about to make an offer. the fridge stays, right? You say, oh yeah, absolutely. The fridge is going to stay, no problem. Offers made and accepted. And guess what never made it to the offer? The refrigerator. The seller agreed on day one to leave the fridge. You put it in your advertising. We verbally said the fridge is going to stay, but it never made it to the contract. My question to you, is the seller legally obligated to leave the fridge? Do they have to leave the fridge? And the answer is no, because the parole evidence rule says the final written word will prevail. So although we agreed to it all day long, and it was never a point of contest, because it never made it to the contract, the parole evidence rule says the seller is not obligated to leave the refrigerator. The final written word will prevail. Then we talk about something, another contract term that we're going to see in our offer to purchase and contract. And the contract term is called time is of the essence. We're going to see some provisions coined, time is of the essence. Time is of the essence is a drop dead date and time. Time is of the essence provision in a contract says that performance has to happen by this date and this time. Something has to happen by this date, this time. If it doesn't happen by this date, this time, then the other party may have a legal out. They may be able to legally terminate the contract. You gave somebody a deadline, very specific. Again, we got a couple places where we see these in our offer to purchase and contract, so we'll talk more about this. But when we look at our contract, we're going to see it very specifically says 5 p.m. on this date. So for example, if we say 5 p.m. on April 20th, that's pretty specific, isn't it? Does it say anytime on April 20th? Does it say afternoon on April 20th? It actually says 5 p.m. on whatever date we put in, which means if that doesn't happen, whatever that is, doesn't happen by 5:01 today, the other party can terminate. Time is of the essence is a drop dead date and time. Contracts maybe can be assigned. If you assign a contract, you're substituting one of the parties. One party is transferring their right or duties to another. In an assignment, all the terms stay the same. The only thing that changes is the name of one of the parties. Somebody is assigning their rights. The assignor is the giver of their rights and duties to the assignee. Whether or not contracts can be assigned have got to be spelled out in the contract. We actually have to have a provision that says yay or nay, this contract can be assigned. I think the best example of an assignment, where are my homeowners on the call? When you guys bought your house, you originated your loan with a bank or a lender. How many of you are still making payments to that same bank or lender? Few of you, but most of us, once we bought our house, that bank or lender sold our loan to another bank or lender, right? You got a letter in the mail saying, I've bought your loan, start sending me your payment every month. We're going to talk about why they do that, that whole process when we get to financing next week. But guys, when that happens, that's an assignment. Because your payment amount didn't change, your interest rate didn't change, the terms of your loan didn't change. The only thing that changed was the name of one of the parties. And in that case, that party was the lender. Bank ABC sold it to XYZ, and that was an assignment. So again, more on that when we get to 14 and 15 next week. Another contract term we have is a novation. In a novation, you're not substituting the parties. you're substituting the contracts. You're changing out one contract for another. Maybe you negotiated on your offer or your contract and you had a lot of strike throughs and changes. Anytime you make a change on a contract, we need to note the change, obviously, and then all the parties have to initial and date acknowledging that change. And if you do that enough times, it's going to get to where after a while that contract's kind of hard to read. So once we make all those changes, we might do a novation. We might substitute a new contract to replace the old one with the newly agreed upon terms. So novation, a substitution of contracts. I actually had a really good example a couple years ago, and I was so excited because I was like, "Yay, I have a story for pre-licensing." But I was a listing agent. It's been a while, and I was working with an investor. They were flippers, so they bought the house, gutted it, redid it, put it on the market. Put it on the market is when I got involved. We were on the market, and we got an offer, and we went under contract. At the time, I didn't know this, but I learned there is the buyer that we were under contract with was getting a type of loan referred to as an FHA. We're going to talk about FHA in units 14 and 15. But FHA loans have certain rules. And one of the rules that I didn't know about was before an owner can sell, they had to have owned the property for 90 days. Everybody with me? So the FHA rules say you can't sell if you don't own this property for 90 days. The day we signed our contract, y'all ready for this? My guys had owned it for 89 days. Grumble, grumble, grumble. Lender called and said, underwriting's going to kick this out. So what did we do? We sat patiently until the next day, got everybody to re-sign it so the dates lined up. We did a novation. We substituted one contract for another so we could be in compliance, so we could get that thing to go through. One day. Rules is rules, right? So we did a novation. We got everybody to re-sign it, everything. We substituted a new contract for an old one. Shake your head, yes or no. Did I keep the old one? Did I keep the old contract in my files and my documentations? You better believe I did, because what do we document? Everything. Guys, let's just put this out there. In real estate, do not throw it away. When in doubt, document it. All right, another question for you guys in the chat. Back in unit 6, we were talking about zoning. We were talking about zoning terms. And one zoning term we discussed was an amendment. In one word, remind me what an amendment is. One word. What is an amendment? Look at you guys go. Van? One word. An amendment is a change. If you're amending something, you're changing an already existing agreement. Let's go back for a second. We talked about a zoning amendment. What are we doing in a zoning amendment? We're trying to change the zoning. So now here we are in contract law. What are we amending? It's a change in the contract. We've agreed, we shook hands, we have a legally bound contract, but for whatever reason, any reason, we decided to go back and renegotiate. We're going to talk about more, again, when we get into our contracts. I need you guys to understand, Buyers and sellers can agree to anything at any time as long as it's legal. So even if we're under contract, can buyers and sellers agree to renegotiate stuff? Absolutely. Absolutely. They can agree to amend. Buyers and sellers can agree to anything. There are no bounds. There are no limits. I want you guys to compare an amendment to another word we've introduced you to. And again, this is the confusion, the difference between an amendment and an addenda. When you see the word addenda, do you guys see the word add in there? An amendment is a change. An addenda adds to and becomes part of the offer, and upon acceptance becomes part of the contract. An amendment is a change, an addenda adds to and becomes part of the offer. The addenda that we've looked at, the addenda that we talked about was back in Unit 20 when we talked about our lead-based paint addenda. We said we're going to use that form anytime the house is built prior to what year? Do your mouths. What's the magic year for lead-based paint? 1978. Anything built prior to 1978, yep, we're going to use our addenda. It adds to and becomes part of the offer. When that offer becomes accepted, it's part of the contract. So again, side-by-side comparison on your flashcards, because I'm telling you, getting amendment and addenda mixed up is a common mistake. An amendment is a change, and addenda adds. Contracts can end just like they can start. They can be created by the parties. Guess what? The parties can agree to release each other. I don't want you guys to get too bogged down in this slide. What we need to know from this slide is the agreement of the parties. How can we discharge a contract? How can we end a contract? Guys, remember the parties agreed to enter into the contract together, didn't they? We had mutual assent. We had meeting of the mind. An offer was made, considered, and eventually accepted. So if they can agree to get into a contract together, doesn't it make sense that the parties can agree to get out of the contract? So the parties could terminate the contract by agreement. They can release each other. They could do a novation, substitute an old contract or new contract for a new modification. Accord and satisfaction is just like partial change. Let's say, for example, I was selling you my house and I promised a, I don't know, a specific brand of dishwasher. I said, you buy my house and I'm going to give you a Whirlpool. And then I go out to buy a Whirlpool dishwasher and they're out of stock. So I got to buy a different brand. I'm still going to get you a dishwasher, but it's not going to be a Whirlpool. That would be accord and satisfaction. It's partial agreement. I'm doing part of what I promised. I'm still getting you a dishwasher, don't worry. But it's just not going to be a Whirlpool. Or we could just flat out cancel it. Long before the internet, that was the old school way of terminating contracts. You physically took the paper and your red pen and you actually wrote the word cancel across it. Again, what we need to get from this slide is agreement of the parties. The parties agree to enter into the contract together. They can agree to get out of the contract together. Other things that'll discharge a contract or end a contract, full performance. When we've done what we agreed to do, the terms of the contract have been satisfied and we're done. We don't have any other obligations or duties to each other. So in real estate, when we go to closing, when that deed changes hands, that contract has been fully performed. The gist of our contract says the seller promises to sell and the buyer promises to buy. That's the big picture of our offer to purchase and contract. So when the seller sells and the buyer buys, done. Buyer and seller no longer have duties and obligations to each other. They have fully performed the terms of the contract. Contracts could be discharged or terminated due to impossibility of performance. Let's say we're under contract. You're under contract to buy my house and my house burns down. Can I perform as promised? Can I sell you my house? It's impossible for me to perform at this point. Let's say I'm buying your house. We go under contract, and lo and behold, I find out I can't get loan approval. Can I buy your house without money? It's impossible for me to perform. Again, mutual agreement. Parties can agree to get out just like they agreed to get in. Operation of law, if the judge takes the property while we're under contract, foreclosure, bankruptcy, that would terminate the contract. Or if either party breaches, breaching of the contract means one party did or didn't do what they promised to do. Our contract is very specific. The seller promises to do this, the buyer promises to do that. And if either party does or doesn't do what they promised to do or not to do, they're in breach. There are consequences of breach. We're getting there. If the judge gets their hands on a contract, they have a kind of a general set of rules for how the judge is going to interpret the contract. We're on page 261. The judge is going to interpret the contract as a whole. They're not going to piecemeal it. Well, this provision works, but this one doesn't. It's an all or nothing. So contracts are interpreted as the whole. Words in contracts are going to be interpreted per their ordinary meaning. I already got you guys starting to speak the language of broker. Y'all are learning a whole new language right now, aren't you? And I already got you starting speaking broker. Brokers are speak, you guys. Buyers and sellers may or may not speak broker. And when we are completing forms and documents and contracts on their behalf, we need to use words that they understand. Does that make sense? Our jargon, our industry language does not belong in their contract. And if we do put our jargon in and they don't understand, then the judge is going to favor inside of the buyer or seller. So we need to not use our jargon. All of our acronyms, I swear, if we can make an acronym out of it, we're going to. Our acronyms do not belong in the contract. Buyers and sellers need to understand the words that we put in. And any ambiguous terms or unclear terms, anything that's not very certain, very clear what it's about, the judge is going to interpret it against the party that prepared it. So again, if you're completing a contract on behalf of your buyer or seller and you're not clear about what you're saying, the judge is going to interpret it against you. They're going to favor your client, your buyer or seller. There's some others on 261. You may want to look those over. The parole evidence rule, I think, is there again. Maybe not. But just to give you an idea, again, if we have to go stand in front of a judge, what are some things that they're going to consider? We mentioned breach a few minutes ago. If either party does or doesn't do what they promised to do, there's got to be consequences for breach. Any good contract, any legal contract is going to have those consequences for breach spelled out. So in other words, when you enter the contract, you know, if you breach, what your consequences are going to be. There's a couple different contract remedies for breach. The first set are money remedies, money damages. If the non-breaching party is going after the breaching party for compensatory damages, they're going after money. But with compensatory damages, they're only going after the amount that they need to make themselves whole again. So what money did they invest in this contract already? I'm not going to go after you for pain and suffering. I'm only going to go after the breaching party for the money I spent in relation to this contract. Compensatory damages is not a punishment. It's just meant to make me whole again, put me financially in the same position I was before we went under contract, before you breached. With buyers and sellers, let's say, for example, the seller breaches. The seller does or doesn't do what they promised to do. The seller terminates. Any inspections or investigations, for example, that the buyer has already performed, that would be an example of their compensatory damages that they could go after the seller. They could say, look, if we never went under contract, I never would have paid for a home inspection. I never would have ordered an appraisal. I wouldn't have put down deposits and fees. I wouldn't have done any of that. And they can go after the seller in court to get that money back. Compensatory damages. I'll come back to liquidated, but let's skip to consequential real quick. Consequential damages or special damages, they've occurred because failure of one party to meet their contractual obligations. These are things that, we can only predict so much, but we obviously can't predict anything that could happen. So consequential damages are kind of things that we couldn't predict, things that happened and we couldn't predict. For example, when we look at our sales contract, we're going to see that the buyer is responsible for any damage to the home caused by either themselves or, like, for example, their home inspector. So if the home inspector damages the property and the buyer terminates, the seller could go after the buyer for consequential damages. We went under contract, you broke my home. I didn't know that was going to happen. There's no way we could have seen that. Consequential damages. Liquidated damages are also money damages. Liquidated damages, what makes them different? We agree to liquidated damages when we enter into the contract. We agree that we're entering into this contract. And if I breach or if I terminate, you're going to get X amount. That amount is completely negotiable. Is it $5? Is it $50,000? That's what we have to negotiate. When we get to our contract, in Unit 10, we're going to see liquidated damages are the seller's remedy. So with liquidated damages, if the buyer breaches, the seller's owed some money. How much? That's negotiable between the parties, but we've got to agree to those when we enter into the contract. So the breaching party could suffer. Obviously, we got to go to court. Compensatory or consequential. Liquidated damages should be paid unless the buyer's unwilling to sit down and write the check. Then the seller can take them to court. No win, because it says right there in the contract, if you breach, you owe the seller this money. But these are all money damages to be awarded to the non-breaching party. Another contract remedy is something called specific performance. Please underline the word perform. Specific performance, the non-breaching party is taking the breaching party to court. And if they win, the judge will make the breaching party perform as promised. For example, where we may see specific performance is in the event of a breaching seller. We go under contract, the seller breaches, the buyer takes them to court for specific performance, and if they win, the judge can make the seller sell. The judge can make the seller perform per the terms of the contract. Specific performance, we see it awarded to the buyer by the judge, not me and you. So if the buyer wins, the judge will make the seller sell. Specific performance. They're going to make them perform as promised. Remember, I just said, guys, when we get to our contract in just a minute, you're going to see today our offer to purchase and contract is 16 pages. 16. The big picture, the seller promises to sell and the buyer promises to buy. It takes us 16 pages to say that. And if the seller decides not to sell, they've breached. And the buyer can go after them for specific performance if they choose. I guess it depends on how bad they want that property, isn't it? Remember the 3 most important things to real estate? Location, location, location. So if they found that sweet spot and the seller breaches, the buyer has the choice to go after them to make them sell. The other contract remedy we have is something called a rescission. If you're rescinding your contract, you're taking it back. If you put down any deposits, you'll get your money back. Some contracts have a certain period of time that you can rescind. You can change your mind. So if you rescind, you take your contract back, you get your money back, and both parties go about their lives as if this never happened. Nobody's out anything. I got my deposit back. This contract's been canceled. We've talked about this a couple times. Remind me in a chat. In a timeshare contract, how many days does the buyer have to rescind? In a timeshare, how many days does the buyer have to rescind their contract? They can cancel their timeshare contract. If they put down any deposits, they'll get those back. How many days does the buyer have to rescind in a timeshare? Getting ready to do it. What do we remember about timeshares? Everyone do it with me? 5, 5, 5, 10, jazz hands. You're not going to be tested on jazz hands. So how many days does the buyer have to rescind? It's either 5 or 10, right? We got that. Narrow it down. How many days does the buyer have to rescind in a timeshare? 5. That's one of our 5s. How many days does the buyer have to rescind their contract for a new construction condominium? Oh, y'all were ready for me. Did y'all know that was coming? How many days does the buyer have to rescind their contract in a new construction condominium? The answer to that one for new construction condominium is 7. 5 days to rescind a timeshare, 7 days to rescind a new construction condo. In real estate, that's all I know of. So that's what we need to, numbers we need to know. 5 for timeshare, 7 for new construction condo. Again, it's spelled out. Buyer terminates their contract, gets their money back, gets their deposits back. Nobody's out anything. Nobody lost anything but time. Both parties go about their lives as if it never happened. Not really a contract remedy, but just another legal term that we need to know about. And again, this doesn't apply to real estate. You guys have probably heard about this one outside of real estate. But the courts have something referred to as the statute of limitations. You guys heard of this before? Statute of limitations says you only have a certain amount of time to bring legal action. What is the statute of limitations? I don't know, I'm not the judge, and it depends from case to case to case. However, what I do know is if your statute of limitations has run out, you've lost the right to sue. You've lost the right to take them to court. So bottom line, if you plan on suing somebody, do it sooner rather than later. Because once that statute of limitations runs out. Questions? So let's bring this back to us a little bit. With basic contract law, what's this mean for us? Well, as real estate agents, I am not an attorney. Is anybody on this call an attorney? Hang on, let me go to my next screen. Keep your hand up if it is. I have never in my career had an attorney in pre-licensing. I would love one, or at least never had one admit to me that they were an attorney. So that's a fair statement, right? We are not attorneys. Thus, we cannot perform the job of an attorney. Because you have a real estate license does not mean you can practice law. We need to stay in our lane. And because we are only agents, we are prohibited from drafting any legally binding document. We cannot draft, we cannot add verbiage or provisions, we can't delete stuff. We cannot amend the pre-printed contract. The only thing we're allowed to do is fill in the blanks. And it's important that we understand that the blanks that we're filling in are very specific. In other words, we can't just see a blank and try to slip something in there. The blanks are calling for a very specific thing. Guys, this is one of these things. It's my job to know the parameters of my job. It's not the buyers and sellers' job to know my job. Isn't that a fair statement? Their job is to buy or sell a house. My job is to assist them through the legalities of it. Your buyers and sellers are going to ask you to amend, to change the contract. Can't you just delete that provision? Can't you just add this? We have to know how to answer that. We have to know how to be able to say, I'm not an attorney. I can't draft. They will ask. I'm telling you, they will ask. And we have to know how to respond to that. If your buyers and sellers want to draft their own agreement, if they want to change anything in our pre-printed forms, we need to advise them to do what? Call their attorney. They'll ask. I'm a heck of a lot cheaper than an attorney. They're going to ask me first. And we need to know how to respond. Y'all get used to this. You're going to hear me say this about 30 more times before we're done. We are not attorneys. And there's a really good reason why I got to say it. We have to say it over and over and over again. Because you guys get licensed, you work with your first buyer, your buyer says, cross that out. And you say, okay, I'm just doing the instructions of my client. You just acted like an attorney. Remember, I follow my clients' lawful instructions. Now, this is important. Remember our old saying, just because you can doesn't mean that you should. The parties to the contract, let's talk specifically about our sales contract for a second. Who are the parties to the sales contract? The parties are buyer and seller. Did I say real estate agent? The parties to the sales contract are buyer and seller. The parties to the contract can change, amend, add, delete, draft. But just because they can doesn't always mean that they should. If your buyers or sellers saying, well, I'm part of the contract, so I can change this and delete that and add that and fix this, da 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 da, I can't stop them, can I? I can't make anybody do anything. But we need to make sure that we're highly recommending that they talk to an attorney, because here's the deal, you guys, the parties to the contract, I always think of the domino effect. If you change something on page 1, how does that affect a provision on page 13? I don't know the answer to that. I'm not an attorney. So before they start chopping up the contract and making it their own, or trying to draft documents, legally binding verbiage on their own, that's where we need to say, whoa, 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 you don't know what you're doing. I would put that a little nicer, but highly encourage them, highly recommend them to have an attorney at least look over the changes, because we don't know the consequences. Does this make sense? Just because the buyer and seller can does not mean that they should. Y'all gonna document telling your buyers and sellers to call an attorney? You're gonna document that conversation? You better believe you are. It's face to face, go home and follow it up with an email. Per our conversation, call your attorney. Everybody with me? Any change to the contract, as we said, any change or addition, anything that's not the original needs to be dated and initialed by which parties? All of them. All of them. You can't have one buyer sign on behalf of 20. You have 20 buyers, all 20 buyers need to acknowledge that change. Questions on this? Page 262 and 263. I really think anytime you guys see the word broker responsibility in your book, I think you should read that. I think that's important. Questions on this? I had a buyer once using a lender. The lender was based out of Texas. Now, I don't know how they do things in Texas, but you know, that lender in Texas called me and said, there's a provision in your contract that we don't do in Texas. I need you to cross that out. The lender told me to do it. And I said, well, first off, you may do that in Texas, but my contract is for the home located in North Carolina. So what state law is going to prevail here? Duh, North Carolina. It's a North Carolina contract for a North Carolina home. Second off, I said, I can't. I don't have that kind of power. And then I hung up the phone and said, oh my God, because I was new. Was I right? And I called my BIC and I said, did I do right? And he said, yes, Julie, you did right. You cannot change. You cannot add, delete. So it may not come from your buyer or seller, you guys. It might come from the professional in Texas. I don't remember now what it was. This is why we need to know this. Okay, let's go ahead and take our break. I got like 2 more things to say in Unit 9, and then we're done and moving on to Unit 10. So let's take 10. we're back. Welcome back. I am going to take attendance. Wrap up Unit 9 real quick. The last thing in your book, we talk again very briefly about auction sales. We mentioned auctions when we were talking about working with real estate agent disclosure. What I need you guys to remember about auction sales is they're a totally different beast. They don't work the same way as a traditional residential or even a commercial sales does. So everybody, please listen. You can stop writing for 1 second. I'll give you plenty of time, I promise. Do not worry about auctions. Don't even think about auctions unless your test question specifically says something about an auction. Do I have everybody? Auctions don't exist unless the test question says something about an auction. And I have taken attendance, so thank you guys. Yep, thank you for letting me know that you're back. Please remember to tell me that you're back. So, auction sales. And if you're not sure if you missed attendance, tell me you're back. That way we know for sure I got you in the chat. So auction sales, I got 2 types of auctions. There's auctions with reserve, there's auctions without reserve. An auction with reserve means that the seller has the right to stop the bidding if they're not satisfied with how it's going. So if the bid starts and it's lower, for example, than what the seller wants, they can say, no, we're not doing this. With reserve means the seller has the right to stop the process. So then without reserve means they get what they get. They don't stop it. One thing that makes, I should say another thing that makes auctions unique, the auctioneer has the right, they can bind the seller. So in other words, when that gavel comes down and the auctioneer says sold, congratulations, we're under contract. Obviously, the next step is going to be to put it in writing. But once that gavel comes down, the seller is bound to sell under those terms to that buyer. Negotiations are over. Auctioneers, by the way, auctioneers are dual licensed, which means they have an auctioneer's license and they also have a real estate license. So auctioneers got to take that extra step. Has anybody ever been to a real estate auction, stand on the front yard? A couple of you have? I want to go. I want to go one day, just kind of stand in the back and observe the whole thing. Good question comes in. What could lead a property to be auctioned? I think where we see auction sales, I mean, there's anybody could choose, like I could choose to have my home auction today, right? Anybody could do it. But I think a good example might be an estate. And you could do like in a combined estate sale, like have an auction for the stuff and then an auction for the property, for example. But anybody, like I said, I could wake up today and say, I'm going to auction my house off. But I think a common example, foreclosure auctions, the bank may auction the property off to try to get their money back, recoup their losses. So the auctioneer is duly licensed. Could the government auction up? I guess if they wanted to. That's a good question. I don't. On the one hand, I think they're the government, so they can do whatever they want to, you know. So if they but I don't know. I don't know if they would for any of their property. Can the court order an auction? Sure. I don't know why the judge couldn't. They may want to order the auction. This is all we're going to say about auctions. Again, we mentioned it briefly back in Unit 7. We hit on it in Unit 10. We're done. Don't think about auctions unless the question specifically says. Is everybody with me? Can I get thumbs ups? Okay. I'm trying to defeat the what if game that I know y'all insist on playing with yourselves. Despite my efforts, how many of you are still playing? What if? And what about this? I know you are. Stop it. I promise you everything you need to know for that question is in the question. You don't have to add to it. The other term, idea, thing I want to introduce you guys to is not in your book in Unit 9. I think it's somewhere in Unit 10. But I do want to go ahead and introduce it now that we're here. So in other words, I'm going off book for a minute. And I want to introduce you to a contract term called a contingency. A contingency is something that's dependent on something else. Common verbiage of a contingency is, I can't do this before I do that. So examples of contingencies that we might see in real estate. I can't buy your house if I can't get a loan. The contingency being, if I don't get the loan, then I'm not bound to buy your house. This has to happen, must happen before this. So if in a contingency, if I don't get a loan approval, I'm no longer legally bound to buy your house. Another contingency we may see, I can't buy your house if I don't sell or lease mine. So again, that may sound something like, if I don't sell my house, then I'm not legally bound to buy yours. That's what we mean by a contingency. It's something on the condition that I get the loan, on the condition that I sell my home. And this is what we need to understand about contingencies. Our standard contract has no built-in contingencies. There is no loan contingency. There is no contingency for me to sell or lease my home to buy yours. Can the parties agree to add a contingency? Can the buyer and the seller agree to add a contingency? Sure. Remember, we just said buyer and seller can agree to anything. If they agree to add a contingency, I don't have a form for that. We do not have contingency forms. So if the buyers and the sellers, if the parties want to agree to add a contingency, what are we going to do? We're going to call our attorney. By the way, I recently learned that some of you younger folks may not know what this means. So if you see us older folks do this, we're talking on the phone. Okay. Did you guys know? Did y'all learn something today? I just found that out. Because guess what? Younger folks don't know about cords and wires for phones. Y'all remember those? Rotary phones, all that good stuff. All right. So contingencies. I don't have a built-in contingency. However, the parties can agree to add a contingency. And that's why we need to know how they work. If the parties agree to add them, then we need to understand how that works. And again, I think we see this somewhere in Unit 10. I feel like I have a hard time finding it in Unit 10. So if I have a hard time finding it, you guys probably do as well. So this is why I want to just pull it out and introduce you to this right now. We'll talk more about contingencies as we go. Questions? All right. Wraps up Unit 9. Again, you guys, the trick to Unit 9 are the vocabulary words. So please focus on those key terms on page 253. If you know what it means, you're good. If you don't know what it means, make a flashcard out of it. 101 of real estate school is knowing what the word means. Remember, you got a glossary in the back of your book. So if you don't know what a word means, look it up. Key point review is your checklist, your Cliff's Notes, if you will. And then you got a student quiz on page 266. Questions on Unit 9? All right, big deep breath. Unit 10. Now we're getting more specific into our sales contracts, our practices, specific to the real estate sales contract. So in Unit 10, the highlight, the star of Unit 10 is our standard offer to purchase and contract. We're going to spend some time looking at this. We're also going to talk about some contract procedures. When it goes from being an offer to a contract, that magic moment in time. Various other things that we need to know. Thank you. And then briefly at the end of Unit 10, we're going to talk about some alternative land conveyances. There's some other options out there that are not the traditional method of buying or selling. So we're going to talk about some alternative methods to convey property. Reference to a couple commission rules about our compensation. We're going to talk a little bit about compensation in this unit. A little bit. We've talked about the big compensation. But just a couple references to some commission rules. Again, you don't need to know these numbers. I just put them here for reference. So let's talk about our sales contract. NCAR is the North Carolina Association of Realtors. We have the National Association of Realtors. That makes you a realtor. When you join NAR, you become a realtor. You also get access into the state level, which is the North Carolina Association of Realtors. NCAR and the Real Estate Commission are two different entities. They are two different bodies. Please don't mix them together. The North Carolina Real Estate Commission gives you your license. The North Carolina Association of Realtors provides us with our standard forms, among other things. Specifically, we're going to look at 2T. Again, you don't need to know that. I'll just put it there for reference. 2T is the most commonly used sales contract when an agent's involved. Here's the problem topic, you guys. A common misunderstanding is 2T is the only contract we're allowed to use. And that's not true. 2T is the most commonly used. But as real estate agents, we can use any sales contract as long as it was drafted by an attorney and it meets the standards of Commission Rule A.0112. Again, it's there for reference. Commission Rule A.0112 gives us a list of, I think, 19 different things that are required if a real estate agent is involved in the transaction. So again, we can't just use any old contract. It's got to be drafted by an attorney and it has to meet the conditions of these rules. You will get more into this rule when you get to post licensing. So I'm just telling you right now, no, there's a rule. We'll spend more time on it in post. It's not uncommon, for example, for builders to use their own sales contracts. Builders might have had their own sales contracts drafted up by an attorney. You take a buyer to the builder is going to insist on using their contract. Can we? Sure, as long as it was drafted by an attorney and it meets this rule. What I need you guys to understand in pre-licensing, again, a commonly missed point is that we can only use NCAR forms. And that's not true. This unit, this pre-licensing, our focus is going to be on the standard form 2T because this is the one that we use the most often. This is the one that we see the most regular. Sales contracts, we just said, are between two parties. Who are the parties? Buyer and the seller. Guess what? You and I do not belong in the sales contract. Why? Because we aren't a party to the contract. This is not our place. Big picture, brokers don't belong in the sales contract. That's for the buyer and the seller. Specifically, the real estate commission says we cannot make any mention of our commission. We've already hashed our commission out, haven't we? We've already decided how much we're going to get paid and when. When did we do that? Back when we did our agency agreements. Remember, commission has already been decided. Would it surprise you guys? I hope not, because people are people. There have been cases where the commission has found agents have been slipping themselves in a $500 bonus in the sales contract. No, we can't do that. We hash out and agree to all of our commission from the one that hired us in our agency agreement. We also specifically can't put anything in, any liability disclaimer. So for example, you can't slip a provision in that says something like, see the school record, and then you be off the hook for misrepresenting that information, right? So you can't like get out of a lie because you put a clause in there that says, well, you're responsible for looking it up. So we can't put anything in there to try to protect ourselves, try to protect our liability. Another example, I had a buyer once. She didn't want the pest inspection. I've never had a buyer decline the pest. It's like $85. She's like, nah, I don't want that. I'm going to have Terminix come out after I buy. And, well, okay, that's fine. But don't you want to know if there's pests before you buy? No, I'm fine. I said, well, I need you to, acknowledge this. But I didn't put that acknowledgement in the contract. I didn't put that in there to protect myself. This was a conversation we had, and I followed it up with, it was actually a text message, but I had my documentation. Everybody with me? I didn't put that because I didn't want her coming after me. She found termites after closing and say, well, my agent didn't tell. Oh, no. So we had this conversation. My point is I didn't put it in the contract. I protected myself in another place. So again, the big picture, we don't belong in the contract. We are not a party to the contract. When it comes to contracts, technology is taking over our world. This applies to contracts as well. When it comes to e-signatures, e-documents, e-world, we're regulated by the Uniform Electronic Transactions Act, known as the UETA. There is a state level known as the North Carolina Uniform Electronic Transactions Act. It's parallel, but we do have a state version as well. What this act does is it specifically regulates electronic documentation, e-signatures. Once the parties agree to use e-documents, e-signatures, those e-signatures become binding. You all, before class started, you all received a request from Lane to e-sign the contract with Carolina School of Real Estate. Y'all remember getting that? You got an email from Lane and you clicked on the terms and conditions and you carefully read that before you said, okay, and went and signed your contract with Carolina School of Real Estate. Yes? Read word for word, very carefully. Did you? Come on. How many times do we read the terms and conditions? There we go. Had you read those, you would have learned that your e-signature was going to count as your binding signature. Everybody with me? Once you agree to those current terms and conditions, part of those terms and conditions says your e-signature is binding, which means, does anybody's e-signature look like their actual handwritten signature? It's rare, isn't it? So that means that you can't come back and say, well, that's not how I signed my name. You agree to let that e-signature count, and that's all regulated by the UETA. We're going to talk more about e-transactions. So flip over, we're skipping the contract in your book because it's out of date. We're going to look at it in just a second. So skip ahead to page 284. And we're going to talk a little bit more about this offer and acceptance. Again, there's two parties when an offer is being made. Not the buyer and the seller, the offeror and the offeree. The offeror is the giver of the offer. The offeree is the receivee of the offer. In most cases, the buyer is going to be the first one to make the offer. In most cases, the buyer is going to be the offeror, which makes the seller the offeree. Please don't get stuck on buyer and seller. It is way too easy on your test to give you buyer and seller. Also, I don't want you guys to get stuck because the seller could make an offer to sell to the buyer. So we're not talking about buyer and seller. We're talking about offeror and offeree. Do I have everybody so far? For example, in this case, the buyer starting as the offeror, they are making an offer to the seller who's the offeree. The seller in this example as the offeree has three choices. The seller can, y'all want to do it together? The seller can accept it, reject it, or counter it. For my visual people, the offeree has three choices. They can accept it, reject it, or counter it. With an acceptance, the offeree is agreeing to all the terms exactly how they are. If they reject it, the offer is dead on the table. Thanks, but no thanks. Parties move on. Nobody's out anything. A counter offer is a rejection. A counter offer is a rejection. And with a counter offer, the roles reverse. The seller now becomes the offeror, making a brand new offer to the buyer, who's the offeree. Is the buyer bound to anything? Are we under contract in a counter offer? No. The buyer has three choices, don't they? The buyer can accept it, reject it, or counter it. If the buyer counters it, the roles reverse again. There is no set number of counters. We could counter till next week. The only thing that's going to kill a counter is when an offeree finally accepts it or rejects it. Ideally, when we're negotiating, when we're countering, you know, the seller, let's just talk about purchase price for a second. The seller starts up here somewhere, the buyer's down here, right? Each counter hopefully gets us closer and closer together. But then we reach this point where we can't get any closer. Maybe we're off by $1.50. People get petty, y'all. Maybe we're so close. Some offeree eventually has to either accept it or reject it. That's the only thing that's going to end a counter. A counter offer is a rejection. Nobody's bound. A counter offer is a brand new offer. So we mentioned back in Unit 9, this idea. There's this magic moment in time when it goes from being an offer to a contract. And you all agreed, you thought this was important to let your buyers and sellers know when they're under contract. Do we still agree? Okay. In order for it to go from being an offer to a contract, step one, I need acceptance, right? I need the last offeree to accept the last offer. That's step one. Once you have acceptance, you're close. but you're not under contract yet. So step one, the last offeree accepts. Step two, communication, I'll redraw my line. Communication of acceptance has to be made to the offeror. In other words, the person making the offer has got to know that their offer has been accepted. So step one, the offeree accepts. Step two, they tell the offeror. They say, I accept your offer. In the real world, acceptance is, well, in the real world, verbal acceptance, if you got verbal, you got nothing. In the real world, when you see acceptance, the acceptance has to be in writing. In pre-licensing world, that's the case as well. But the problem topic with pre-licensing, anytime you guys see the word accept, just know that it's in writing. Just know that it's been signed. In the real world, you need to verify it. You need to verify that it's been signed. In pre-licensing, let me make this easy for you. When you see on your test that it's been accepted, has it been signed? In pre-licensing world? Yes. Everybody with me? On your test, for your exam, if that doesn't get your attention, I don't know what will. For your test, when you see that an offer has been accepted, just know that it's been signed. In the real world, yes, you need to verify it. When another agent calls you and says, my guys have accepted, that's nice, but have they signed it? Pre-licensing world, I've already verified it. Everybody with me? So, back to our contract communication wall. I got the buyer on one side as the offeror, the seller's on the other side of the contract communication wall as the offeree. Buyer makes an offer to the seller. Seller has three choices. They can accept it, reject it, or counter. If the seller counters it, then the roles reverse. The seller has rejected the buyer's offer, and the seller is now making a brand new offer to the buyer. The buyer's not bound to anything. Why? Because the buyer now has three choices. The buyer can accept it, reject it, or counter it. It's the power of repetition, right? Let's say the seller counters and the buyer accepts. It has been signed. At this point in time, are we under contract? The buyer signed it. Are we under contract? No. I'm close, but not yet. Step one is to accept. Step two, communication of acceptance must cross the line. The buyer has got to notify the seller that they have accepted their offer. Think about it. I sign a piece of paper and I never tell anybody. What does that piece of paper mean? Absolutely nothing. If nobody knows it's signed, what does it mean? Absolutely nothing. How do I make it count? I tell the person that gave me the offer that I have signed it. Again, I'm bringing agents into the mix in just 1 second. This is what I need you guys to do. When you see this question on your exam, you'll see practice questions. When you get this test question on your exam, the question itself is going to be about this long. You're going to have a whole paragraph. And there's going to be some counter offers. We're going to go back and forth. We're, da, 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 da. When you guys see these questions, I highly recommend that you draw the contract communication wall, that you show this back and forth. There'll be some counter offers. There's a whole lot going on in that question. And I need you guys to draw it out, the contract communication line, so you can see that exact moment in time when the offeree accepted it and communication of acceptance has crossed the line. There are several different acceptable forms of communication. We're going to talk more about these in a minute, but maybe I call you and I tell you, my guys, or maybe the buyer calls the seller. I'm sorry. The buyer calls the seller and says, yeah, we've accepted it. Did that communication cross the line? Didn't we notify you? Yeah. Next thing I'm going to do is obviously email you the contract. But guys, understand this says communication of acceptance. This does not say put the signed contract in your hand. So communication can happen. Email, text, snail mail, document. I'm not looking for a contract. I'm looking for communication of acceptance. And again, we'll talk about more about communication in just 1 second. So this is that magic moment in time. This is when you know you can actually call your client and say, we are under contract. Let me bring agents into the mix. This magic moment in time, I must have two things. We must have acceptance, and then we must have communication of acceptance. Then and only then are we under contract. Questions so far before we bring agents in? What do we look like when we get involved here? All right. So buyer and seller have hired agents. Once we are in the picture, when it comes to communicating acceptance, talking to me, communicating acceptance to me is just as good as talking directly to my client. So when one agent calls another agent and says, my guys have accepted, are we under contract? Yeah, because talking to me is just as good as talking to my client. So now let's look at our contract communication wall again. Only this time, buyers and sellers come with agents. So on this side, you have an agent working with the buyer who's making the offer. And then on the other side, you have an agent working with the seller who is receiving the offer. You are the buyer's agent. You take your buyer out this afternoon and show them a property for sale. Your buyer walks in the front door and says, this is it. This is my dream home. This is the house I've been looking for my whole life. Let's write it up. You do your little mini happy dance. You go home or get your computer. You go to the e-documents and you fill out the blanks. You have conversations with your buyer about what they want to offer. Purchase price, closing day, deposits, fees, all that stuff that we're getting to. You and your buyer fill out the blanks in the contract. Offer, excuse me. You and your buyer fill out the blanks in the offer. Your buyer signs the offer. Does that show the seller this is a serious buyer? Not only are we going to present this offer to you, but we're going to include your buyer's signature. Your buyer signs the offer. You deliver the offer to the listing agent. Maybe you email it to them. Maybe you drop it off at the office. There's no right way to do it. Somehow you deliver that offer to the listing agent. Listing agent calls their seller and says, we have an offer. Seller says, yay. You as the listing agent tell your seller, you have three choices. You can accept this offer, agree to all the terms exactly how they are. You can reject this offer or you can counter this offer. The seller says, I'm good with most of the terms, but not all of them. The seller has created a counteroffer. The listing agent goes through the terms with the seller. If we're on paper, ideally contract law, we're on paper. We make those changes on the offer. The seller initials and dates the changes. Roles reverse. Listing agent calls a selling agent and says, my guys have countered. Selling agent calls their buyer and says, the sellers are good with all the terms except the purchase price. They don't want to pay for your home warranty and they can't close on that day. They've created a counter, right? We're good with everything else. It's just these three things that we can't agree on, that we haven't agreed on yet. Your buyer says, that's fine. I accept. Accept means they have signed. Don't question that on your test. If they've accepted it, they have signed it. Your buyer calls you and says, we have signed the counter. Did communication cross the line when your buyer calls you? Did communication cross the line? Did it? Look at my arrow. Look at the line. Did communication cross the line? No, we're all over here on this line together. Your buyer calls you and says, we've accepted. Are we under contract? Not yet. You call or text or email the listing agent and say, my guys have accepted. Did that communication cross the line? Congratulations. You're under contract. As the listing agent, what's the very next call you should make? Who doesn't know yet? As the listing agent, don't you need to call your seller and tell them the good news? But guess what? Because agents stand in place of their clients with communicating acceptance, once that communication crosses the line between the agents, congratulations, we're under contract. Now, when you're calling your seller, you're not saying, are you still sure you want to sell? Now you're calling the seller and saying, you're under contract. Communication has crossed the line. And this is why I want you guys to draw the line, because that paragraph that's like this long on your test, it's going to have agents calling their clients, agents calling each other, counter offers. There's going to be this scenario. And I don't know about you, I'm a visual learner. So if you're a visual learner, I highly recommend drawing out the contract communication, because you need to know who the last offeree is, who has to accept it, and you need to know who the last offeror is and when they receive that communication. I got a question coming in. Calling without sending the signed paper? Exactly. I'm not delivering documents yet. I'm just communicating. I'm letting you know that my guys have accepted it. Obviously, as soon as I get back to my laptop, what do I need to do? Don't I need to send the other side that signed contract, right? But because they haven't received it yet, that doesn't matter, because we have communicated acceptance. Is everybody here? I could send you a text. I could call you. I could deliver the contract. We're going to talk about the different methods of communication, but communication and delivery are two different things. So this magic moment in time, we have the last offeree accepts, and then communication of acceptance crosses the line. I will get you the signed contract later this afternoon or later this morning, as soon as I possibly can. But we've got to communicate. What if? I know we don't like to play the what if game, but sometimes it's fun. What if? What if? What if? You're the buyer's agent. You're out and about, you're running errands, you're doing your thing, showing property, whatever. You're out and about. And your buyer calls you and says, we've accepted the offer. When your buyer says they've accepted, what does that mean in pre-licensing world? It means that they have signed it. You're out and about, you're in your car, you say, great, thanks so much, let me get back to you. And then you hang up and you get busy because you're doing this and you're doing that, and you're doing this and you're doing that. Remember, we just said you're not under contract yet, are you? So you're out and about, you're going to get home after lunch. You got, plans with a girlfriend to go have lunch. You got to do this, you got to do that. You get home about 3 o'clock this afternoon and you're about to communicate acceptance. And the listing agent says, oh, my guys had a better offer come in and they went ahead and signed it. So we're already under contract. Do you have happy buyers? Should you have pulled over when you got that call and crossed that line, had that communication cross that line? Guys, you're not under contract until you tell the other side. So if another offer swoops in the meantime, and it's better, we've got to have both of those steps. I was doing an open house a couple years ago and this couple came in and I said, hey guys, welcome. How's the weather? Have a look around. Let me know if you have any questions. Did I hit for substantial contact? No. Came in and said, all right. So they went toward the home. They came out. I said, you guys have any questions on the property? And they said, nah. They said, we're just kind of, they said, we already have an agent. I said, cool. And they said, we're just kind of out looking. They said, we feel a little defeated. Said, we made an offer. We found what we thought was our dream home. We made an offer. And before we could sign it, the seller accepted another offer. And then he said, I will never forget this. I'm sorry, but we just don't play that game. Guess what? This isn't a game. This is contract law. This is contract formation. Should the guy be upset? I mean, sure, I felt bad for him because his offer, like I said, another offer swooped in. The seller, we'll talk more about that. But until that communication crosses the line, so again, earlier example, your buyer calls you and says, we've accepted, pull over and call or text the listing agent right then. You can send them that signed offer later this afternoon. Is everybody with me? Communication and delivery are two different things. But if you don't communicate acceptance, we're not under contract. And you risk having a better offer come in and your buyer's losing out. What? Because you were busy and you had lunch plans? Do you have a happy buyer? No. Yes, ma'am, Annette.
I'm sorry, I just want to make sure I'm understanding this correctly. You're saying once you accept the offer, say I'm the buyer and I've accepted it, which means sign, just you calling the seller's agent and saying that I've already accepted, that's all the communication needed, even if you don't get the paperwork to them in order for the seller to sign.
That's exactly what I'm saying.
Oh, okay. Because
what am I going to do as soon as I get home, Annette? What am I going to do as soon as I get to my laptop?
Send my contract terms.
There you go. But we're already, you just said it, boom, boom. We are already under contract. The paper has to be signed. Yes. Acceptance, please write this down. Acceptance equals signed for pre-licensing. In the real world, the other agent calls you and says, my guys have accepted. Your knee-jerk reaction is going to be to say, yes, but have they signed it? I'm trying to help you guys for your test. You don't have to worry about that. When you see the word accepted, you know it's been signed. And communication, what I'm communicating is acceptance. So I can communicate acceptance by the document itself, email, text, phone call, carrier pigeon, I don't care. Whatever form of communication the parties agree to. Communicating of acceptance of an offer. Again, maybe I'm delivering you the offer. Maybe I'm just communicating acceptance. Different methods of communication. I could call you, I could fax you, I could snail mail. There's also the more modern methods. I could email you communications of acceptance. I could text it to you. Message in a bottle, whatever. Communicating acceptance is whatever method the parties agree to. We have a place in our contract. We have a page for communication. So when we're doing the offer, when we're preparing that contract, we know how the acceptable forms of communication. So if one of the parties says email only, what is the only acceptable communication of acceptance? The only thing you can use to bind these people is by email. So that's what we mean. Any form of communication of acceptance is okay as long as the parties agree. Can the seller change their mind after accepting an offer on the phone? So they've accepted it, which means they've signed. Has that communication crossed the line? That's what I need to know if we have that second piece. If that communication has crossed the line, no, we're done. We're under contract. If they change their mind, they're in breach. A contract has been formed. Just because you don't have it in your hand yet. Again, you guys, communicating acceptance and delivery are two different things. You call and say, my guys have accepted. Congratulations. We're under contract. As soon as I get home today after lunch, or as soon as I can safely pull over in the Sheetz parking lot and send you an email with that document. But that communication has happened. Again, any method of communication of acceptance is okay as long as the parties agree to it. If they say, I don't care, just call me, then any method, or call, email, fax, text, any method is okay as long as the parties agree. Couple quick things. In your book on page 286, we have an old school rule about snail mail called the mailbox rule. Now, I know we're not doing much via snail mail anymore, but is the USPS still around? Or is the post office still a thing? So could we communicate this way? Yes, and that's why we need to talk about the mailbox rule. You guys like to give me a lot of pushback on this. Who mails it today? I don't know. Guys, not everybody has an email. Not everybody has a computer. So don't assume the entire population has electronic methods. Maybe you might bump into snail mail. And this is where the mailbox rule comes into place. The mailbox rule is one of the oldest rules we have in this country. It dates back to the days of like the Pony Express in the Old West. You guys ever seen any old Western movies and the Pony Express? What the mailbox rule says is that communication of acceptance has happened when the properly addressed envelope hits the federally related mailbox. So once you leave it in the hands of the United States Post Office, once you put it in that big blue mailbox, or you actually take it to the post office, communication of acceptance has happened. It doesn't matter that they're not going to receive it for a couple days later, right? The mailbox rule says communication of acceptance has happened once it hits the federally related mailbox. This is not the mailbox on your house. It's got to be, absolutely, it's got to be postmarked. You have delivered it to the USPS ready to go. So thank you. It's got to be postmarked, properly addressed. Again, you guys, this is not the mailbox at your house. This is either the big blue mailbox or physically taking it to the post office. Once you leave it with them, addressed and postmarked, communication of acceptance has happened. The other side will get the offer a couple days later. The other thing about communication of acceptance when it comes to email or electronic, communication of acceptance happens electronically when it hits the recipient's inbox. Not when the sender sends it, not when the recipient opens it, but when it hits their inbox. Communication of acceptance has happened. Now we're going to walk through a couple scenarios when we get back from break about this communication. But is everybody hearing me? Communicating acceptance. I will get you the document later. We're communicating the fact that the offeree has accepted. And that's what puts us under contract. That's what creates a legally binding agreement. The offeree accepts, and then they tell the offeror, I have accepted. Questions so far? Again, we'll walk through a few scenarios after break. Okay, break time. Take 10. Welcome back. I am taking attendance. Make sure I can see you, please. We're going to talk about this communication thing a little bit more. First off, I need to go back to the mailbox rule real quick. The mailbox rule, this rule only applies when we are creating a contract. The mailbox rule doesn't apply when we're making the offers. If we're terminating a contract, the mailbox rule only applies for communicating acceptance of a contract. Once it hits the federally related mailbox, you're under contract. Communication has happened. Again, we don't see that much in the real world. We're using electronic methods today. However, it's in the syllabus. Could you have a test question on the mailbox rule? Sure. I have had people, I was the listing agent, the buyer's agent called me and said, my client doesn't have an email and they live in Minnesota. Now, we used FedEx overnight delivery. I'd hate to see that bill. Guys, not everybody has an email. Please, please don't assume that they do. Somebody knows somebody that doesn't? My father-in-law is 76 years old and he got his very first email address last week. What do I do with this? We'll teach you. Don't worry. We'll help you. That's why you have kids and grandkids, isn't it? Okay. So let's go back to our test questions. You guys remember that big long test question you're going to get very in depth about when it goes from being an offer to a contract? You need those two things. You need the offeree to accept, and then you need the communication of acceptance to cross the line. When that communication of acceptance crosses the line, the other thing I need you guys to really make sure that you're looking at. I only need communication to cross the line once to put us under contract. So let's say, for example, what we may are more likely to see in the real world, if we're going to use a mailbox, if we're going to use a snail mail, I go to the post office and I deliver the contract. And then I leave the post office and I text the agent to tell them that I had mailed the contract. And then I call them and leave them a voicemail. Tell me in a private chat, 1, 2, or 3, which form of communication put us under contract? I went to the post office, I followed it up with a text, and then I left you a voicemail. Which one put us under contract? 1, 2, or 3? The one that put us under contract is when I mailed the contract. The text is a follow-up. The voicemail is a follow-up. What I'm telling you guys, when communication of acceptance crosses the line, I only need it to cross the line one time. The first time you see in your test question, that big long paragraph, that first method of communicating acceptance that crosses the line is what puts us under contract. Everything else after that is a follow-up, and it is meant as a distraction. What is a distractor's job? To distract you. I'm getting these, but what about? Stop the whatabouts. What are the two things I need to go to be from an offer to a contract? I need the offeree to accept it. If the offeree is accepting it, what does that mean? Everybody show me, what does that mean? They are signing it. And then we need communication of acceptance to cross the line just one time. If I email it to you and then call you, I email you and then I call you to tell you that I've emailed it to you. Didn't the email happen first? What put us under contract? When it hit the recipient's inbox. Is everybody with me? Guys, I'm telling you that test question, you got practice in the online learning system in your book. But those test questions are throwing stuff in there like follow-ups, like text and voicemail to distract you. I only need communication to cross the line one time. Congratulations, we are under contract. Everything else is a follow-up for me to make sure that you received my email. Does that make sense? We're under contract. I can be like that little natty thing that gets in your face and doesn't leave you alone. You're better just to call me back or acknowledge my text because I'm going to keep at you. But guess what? That's just me being a little obnoxious. We were under contract when I emailed that to you. Thank you for telling me you're back. We have taken attendance. Please remember to tell me you're back. Thank you. So let's look at an example real quick about, we said acceptable forms of communication. In other words, when we look at our contract, we're going to see a page in the contract where the parties have to agree to what forms of communication they find acceptable. So an owner offers to sell to a prospective buyer. The offer states that the acceptance must be made by email message only. What's the only acceptable form of communication? The contract says email only. Instead, this buyer leaves a phone message informing the seller that they've accepted, but guess what? It's not been legally accepted because what's the only acceptable method of communication in this case? Email. So if the parties have to agree to the different methods, and that's where we have our contract to help us with that communication. What questions do I have? Fax, if the parties agree to fax, absolutely. Can I fax you our signed contract as a communication as long as the parties agree? Yep. Carrier pigeon, message in a bottle. However, the parties agree. By the way, we're getting closer to look at our standard form. We're going to see this spelled out in our actual contract. Our contract tells us this moment in time when it goes from being an offer to a contract. So when we look at our standard sales contract in just a minute, we're going to see this again in contract speak. Anything else? Bottom of page 286, we talk about the different ways that the offer can be terminated. Please note that word says offer. We talked about terminating a contract back in Unit 9. But what if the offer never becomes a contract? Well, we've already said a rejection or counteroffer terminates an offer. Other ways that we could terminate an offer. If the offeree fails to accept within a stipulated period of time, the offeree is who? Don't say buyer or seller. The offeree is who? The receivee of the offer. So you make an offer, and maybe in your offer you include a time frame. Maybe in your offer you say you have until 5 p.m. today to respond. If they don't respond by 5 p.m., the offer is terminated. If you give them a time period, If you give them the stipulated time period when you make your offer and they don't respond within that time, it could also terminate within a reasonable amount of time. Who determines in a reasonable amount of time? Usually that's the offeror. The offeror is free to reject their offer, or free to revoke their offer at any time prior to acceptance. The offeror is free to revoke their offer. They can take their offer back anytime prior to acceptance. I make an offer, a week later, I haven't heard from you. I can decide that that's a reasonable amount of time and I can revoke my offer. I can make an offer now, go see another property at noon that I like better, and I can revoke my offer. The offeror is free to revoke their offer at any time prior to acceptance. Is it possible for that party to submit another offer? Absolutely. Absolutely. At any time. Yep. As an agent, would I consider a reasonable amount of time? That's up to my client, right? If they want a response in 30 minutes, I don't think that's reasonable, but I'm not the one making the offer, am I? You know? So some people have different levels of patience. Can we agree? Some people are more patient than others. The other thing that'll terminate an offer, again, please note that says offer. I'll get you in just 1 second. Death of either party will terminate the offer. Again, who are the parties to the sales contracts? So if the buyer or seller passes away before the contract's formed, it's going to terminate the offer. This is interesting. Death is only an out for an offer. Death is not an out once we're under contract. If either party passes away after the contract's been formed, their heirs are expected to carry through with the terms of the contract. And if they can't or won't, they suffer the consequences of breach. Once a contract's been formed, aren't the parties' intentions clearly stated? Don't I have a legally binding document saying, yes, I want to sell you my house, or yes, I want to buy your house? Death is not an out once we're under contract. Look at y'all's mouths agape. I love it. Death is only an out for an offer. We'll see that in our contract. The parties and their respective heirs. When do heirs kick in? They pass away. Death is only an out for an offer. Yes, ma'am, Annette.
When you say the reasonable amount of time, say I'm mailing my acceptance and it gets lost in the mail. If it takes longer for that acceptance to be received, would they be able to?
When you mailed that acceptance?
No, if I mailed it, did the mail by USPS. Say
you're under contract.
I'm under contract, but say they never receive that my contract or my
deliver it again. You need to deliver it again. You're under contract when it hits the mailbox.
But if
not
you can't,
when they receive it.
Okay, but if you can't prove that you actually put it in there, if it's lost in the mail.
Well, maybe you do certified mail, right? I mean, maybe you have, that might be a thing that we want to document if you're going the mailbox route.
All right.
Communication and delivery are two different things. So you mailed. Did we have a problem with USPS during the pandemic and mail was taking a while, right? Yeah. It doesn't matter how long it takes to get there. Basic contract law says you've got to communicate acceptance, and the mailbox rule defines communication of acceptance when it hits the mailbox. So you don't get it for 3 weeks. You know, I should try to send you again. Of course, we're going to talk at some point because you're going to call me and you're going to say, Julie, I thought you said you mailed me my contract. I haven't gotten it yet. You with me? I mean, communication is huge. But I need you guys to separate communication of acceptance versus actually having the document in your hand. Those are two totally different things. Maybe a dumb question, no such thing. Could the signed contract be sent to a family member if they don't have an email? Excuse me, a family member's email if they don't have one? As long as the parties agree to that as an acceptable communication method. So if your 76-year-old father-in-law doesn't have an email address yet, and the parties agree, send it to me. I'll get it to him. The parties got, are we hearing the common theme here? As long as the parties agree. Consider this, you guys. I hear you. I hear you. Some of you are grumbling a little bit, and I hear you. Consider this. Let's step aside just for a second. Every single buyer, every single seller, and every single property are different. And the combination of those three make for a unique transaction every single time. I can't tell you when you get your license that all your communication is going to happen via email or text or phone call. It's situational based. And I can't tell you all the possible situations. What I can tell you are these fundamentals, this foundation, this basic understanding of when it goes from being an offer to a contract. So we have that basic understanding. So now we can put our buyers and sellers under contract. Every transaction is different. Agents that have been in real estate for 30 years are doing a transaction today that they've never done before. They are all different because the unique combination of buyer, seller, and property makes for a different transaction every single time. The only consistency to real estate, the only thing consistent to real estate is change. Things are going to be different. Things are going to be situational based. So we're building your foundation. We're giving you the basic fundamentals you need for the real life situations. And that's what makes me nervous about the what ifs. Anything else? So before we look at our standard offer to purchase and contract, we're going to see that our contract, as well as our agency agreements, also come with guidelines for completing. So again, if you're stuck on something, and I'm going off book, by the way, I'm not on book. Remember, my PowerPoints are available if you don't want to write down every single word. And we are also recording. But our contract, as with our agency agreements, come with guidelines for completing. And the guidelines for completing gives us specifics, kind of guidelines, you know, to make sure that we are helping our buyer and seller properly prepare these legally binding contracts. So the guidelines say, when at all possible, type, if you have to handwrite a contract, if you have to handwrite an offer, do it in ink and do it legibly. Don't do a legally binding contract in pencil or purple crayon, right? So we're going to do it in ink. We're going to do it legibly. If you can't get to a laptop, we fill in all the blank spaces. We don't leave a blank blank. And if you have a situation where a blank doesn't apply to this situation, then you write NA for not applicable. We've got to acknowledge each blank, and we do that for two reasons. One, I don't want the other side to think that I accidentally left it blank. So by putting it in A, I'm acknowledging that it's not applicable. The second reason we do this, I don't want the other side to slip something in without me knowing. So by putting NA, I'm reserving that blank for not applicable. So don't leave a blank blank. As we said earlier, we need to be precise. My real estate language jargon does not apply to the sales contract. So spell things out. Make sure your buyers and the sellers understand what you put in. Again, as we said, every change, addition, deletion needs to be acknowledged, initialed, and dated by all parties. And then we're going to review the contract provisions with your client, with your party, whomever you're working with. I just said that offer to purchase and contract is 16 pages now. Every revision, we grow a little bit. So now we're up to 16 pages. Guys, I'm going to tell you this right now. Buyers and sellers don't, for the most part, read sales contracts. They don't read them. Why? Because they have us. They have the expectation that we're explaining these provisions to them, that we're having the conversation. I will send an offer or a contract to my party to sign, and I e-sign, and I'll always say, let me know if you have any questions before you sign it. A minute and a half later, that signed document is back in my inbox. Did they have time in a minute and a half to read that 16-page contract? I'm telling you right now, they, for the most part, you will come across a reader every once in a while, but they, for the most part, are not reading these sales contracts. Why not? Because they have us. That's part of what the expectation that we have is that we're guiding them through. So what I'm telling you is we need to be familiar with the contract. Yes, because we need to make sure that we're reviewing these provisions, we're having these conversations, pulling out the more important things. Staying off book. I want to go over, before we look at our contract, I want to introduce you guys to some common provisions. These tend to take a few trips to wrap your brain around. So my thinking is introduce you to some of these concepts now. We'll look at the contract in just a bit where we'll see them actually in action. And then, of course, you guys are going to review them, review the YouTube recording, review it in your book. So again, I'm staying off book, but I want to introduce you guys to a few provisions that we're getting ready to see in our contract. And I'm going to introduce you guys to some terms. There's something called a due diligence fee, a due diligence period, and an earnest money deposit. We're going to break these down and talk about these now, and we'll see them all again when we get to our contract. So our sales contract has something called a due diligence fee. It has a due diligence period. And then we also have an earnest money deposit. DDF, DDP, EMD. You have that jotted down. You guys good if I use the abbreviations? DDF, DDP, EMD. When the buyer goes under contract, the day almost the buyer goes under contract, they have two checks that they need to write immediately. The first check is the due diligence fee. The second check is the earnest money deposit. They're two different things. They do two different things. In our vernacular, in real estate language, typically a deposit is money that you can get back. Typically, a fee is money that you can't get back. Typically. So in our vernacular, a deposit may be refundable, while a fee generally is not. I'm going to go back for 1 second. Typically speaking, I just said we went under contract, buyer writes two checks. Are they going to get their due diligence fee back? Typically speaking, a fee is usually non-refundable. Typically speaking, could they get their deposit back? Typically speaking, yes. This is what our contract spells out. So again, a deposit typically is refundable, a fee is not. So let's talk first about the due diligence fee. Don't ask me about the earnest money deposit right now. We're just going to focus on the due diligence fee. Everybody with me? The due diligence fee is a negotiable amount paid by the buyer to the seller. What? We're going under contract and the buyer has to pay the seller? Yeah. The buyer pays the seller a due diligence fee. It's a negotiable amount, which means there is no standard amount. It's completely agreeable between the real estate commission, or I'm sorry, between the buyer and the seller. But I was going to say, the real estate commission is very helpful when it comes to the due diligence fee and the negotiable amount. What the real estate commission says is whatever the buyer is willing to offer and the seller is willing to accept. If the buyer offers $1 and the seller has accepted it, a legally binding contract has been formed with a due diligence fee of how much? $1. Why? That's very common. North Carolina is unique with the due diligence fee. If you bought a house in another state, you've never heard of this before. So it's a negotiable amount, negotiable between the parties, that the buyer pays the seller when we go under contract. And I see y'all scratching your heads going, why the heck is the buyer paying the seller? What the buyer's paying the seller for is a period of time to give them the right to terminate without any consequence. Who remembers caveat emptor? Caveat emptor means what? We can say it together. Buyer beware. What does the seller have to disclose? Nothing. What does the seller have to repair? Nothing. What does the seller have to do to help the buyer through this transaction at all? Nothing. Caveat emptor. The answer, the solution for is caveat emptor fair to the buyer? No, they don't get anything. They don't get disclosures. They don't get repairs. They don't get anything. So what's the solution to caveat emptor? Let's give the buyer a free look period. Let's give them a period of time where they can learn about the property on their own, since the seller doesn't have to disclose. And if they decide during this time that they're not happy with the property, they can terminate with no legal actions or consequences to them. The buyer is paying the seller for the right to terminate. And if they terminate within their due diligence period, during that free look period, they've lost their right to terminate. It's a fee. Is the buyer going to get that back? No, it's non-refundable. If the buyer terminates, they've paid for that right to terminate. So if the buyer terminates, as we just said, do they get their fee back? And the answer is no. They have a period of time known as the due diligence period, DDP. DDP. If they terminate within the due diligence period, they have exercised their right to terminate. The seller can't sue them for terminating because the buyer paid for that right. Somebody came in, I always thought of this as payment for time off the market, and that's a very common misconception with the due diligence fee. Guys, if we go under contract, the seller can still allow showings. The seller could accept a backup contract. So even though we go under contract, the seller doesn't have to stop finding a buyer. What the buyer is paying the seller for is the right to terminate. So the due diligence fee, buyer pays the seller when we go under contract. Maybe it's $1, maybe it's $100,000 coming out of this market we were just in, where due diligence fees. I did see 6-digit due diligence fees. My question to those buyers is, where the heck did you get that kind of money? But, you know, whatever the buyer and seller agree to, we go under contract. Buyer cuts a check to the seller. And that's the buyer paying the seller for the right to terminate. And if they do, they've exercised that right to terminate. The seller can't sue them for terminating the contract. That's the due diligence fee. Now hang on to that. I'm coming back to it in just a second, because the fee and the deposit work together, kind of. So the due diligence fee. Question comes in, if that's the case, why do we take it off the market once the check is deposited? Because that's the seller's request. We have to have the current status. So if it's under contract, we have to indicate it as such. But that doesn't mean we can't allow showings. That doesn't mean, again, you guys, we have a backup contract. You could have a backup buyer that we'll talk about. So I'm getting there. I got a lot of questions coming. I promise you, I'm getting there. Everybody, please bear with me. This is one of these discussions I wish I could open my mouth and it all fell out, but it doesn't work that way. So just bear with me. Everybody good? Big deep breaths with me. Okay. Due diligence fee is one of the monies that the buyer pays when we go under contract. This is the one that they pay directly to the seller. The other money that the buyer pays when we go under contract is the earnest money deposit. Once again, this is a negotiable amount. Whatever the buyer's willing to offer and the seller's willing to accept. The earnest money deposit shows the buyer's good faith. The earnest money deposit shows this seller that this is a serious buyer. They're not just out there kicking tires. They are genuinely interested in buying this home. The more earnest money, the seller's going to see that as more good faith. Think about this. Sellers selling their house. We go under contract to sell their house. Don't they have to make arrangements to live somewhere else? They either got to buy another house or sign a lease. Yes? They got to live somewhere. They can't live here anymore. I'm not looking for a roommate. I'm looking for somebody to buy. And so the seller wants to know there's some good faith. The seller wants to know that this is a serious buyer. This check is made out to an escrow agent. An escrow agent maybe is the real estate firm. More often, it's going to be our closing attorney. The escrow agent is an impartial third party. The escrow agent is simply holding the earnest money deposit on behalf of the buyer and the seller. So let me back up. We go under contract. We've negotiated the purchase price, the amount of the due diligence fee, and the amount of the earnest money deposit. We go under contract. Buyer cuts 2 checks. One made out directly to the seller for their right to terminate. Another one made out to the escrow agent to show their good faith. With the earnest money deposit, will the buyer get their deposit? If the buyer terminates, will the buyer get their deposit back? And the answer to that is, it depends. Maybe they'll get the earnest money deposit back. Maybe they won't. They're not getting the due diligence fee back if they terminate. They paid for that right. We talked earlier about breach, buyer breach. The buyer is not considered in breach until after our due diligence period. If the buyer terminates within due diligence, they've exercised their right to terminate. That's what they paid for. If they terminate after due diligence, Now they are in breach. They're not considered in breach until after that due diligence period. They have paid for a free look. They have paid for an opportunity to decide if they want to buy this house. What did the seller tell them about this house? What did they disclose? Absolutely nothing. Remember what we said very early in our class? Don't buyers have a right to know what they're buying? Don't they have that right to know what they're buying? So if the seller doesn't disclose, I don't want to take that right away from the buyer. If the seller doesn't disclose, I think the buyer should still have the right to know what they're buying. And that's why they're given this period of time, this due diligence period to look. So they're not in breach until after due diligence. Why? Because that due diligence period is their right to terminate. And the contract actually says their right to terminate for any reason or no reason at all. That's what I mean by free look. They could have a home inspection and that report could come back and say, everything's bad. The roof leaks, the electrical's bad, the plumbing's bad, the structural shot, there's drainage issues in the basement, bad, 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 bad. And the buyer could say, my gosh, now knowing what I know about this property, I don't want to deal with it. So I'm going to exercise my right to terminate. Or they could terminate within their due diligence period for no reason at all. Guys, they literally could wake up the next day and say, nah, I don't want to buy this house. Any reason or no reason at all. So now back to our question. Are they going to get their earnest money deposit back? We've already decided they're not getting their due diligence fee back. The question was, are they going to get their earnest money deposit? We said it depends. If the buyer terminates within their due diligence period, they'll get their earnest money deposit back. If they terminate after the due diligence, they are now in breach and the seller gets the earnest money deposit back. The yardstick to determine if the buyer gets the earnest money is that due diligence time is of the essence. Drop dead date and time. Our contract says that the due diligence period ends on 5 p.m. on, and then we have a blank to put in a date, completely negotiable. So at 5:01 on our due diligence date, if the buyer terminates for any reason, they are in breach, and that earnest money deposit will go to the seller, plus the seller will keep the due diligence fee. So to get their earnest money back, they have to terminate before due diligence. Are they giving money up? Are they losing money? Yes, but they're not locked in to this transaction where the seller didn't have to disclose, where the seller didn't have to share any information. Again, you guys, you get this home inspection and there's roof problems and a leaking basement and electrical and plumbing and structural. Is anybody else hearing cha-ching, 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 cha-ching? And it might be that you find out during your inspection period that shortly after you buy, you're going to have to invest $50,000 more into this home to keep it from falling down. Is it worth losing a couple thousand for due diligence to save yourself $50,000? I can't answer that for you. That's up to the buyer to decide. The due diligence period is the buyer's time to determine, now knowing what I know, after doing my inspections and investigations, now knowing what I know, do I want to move forward with or terminate this transaction? If we terminate after due diligence, the seller will keep the due diligence fee. They will get their earnest money deposit, and together the two equal the seller's liquidated damages. Liquidated damages back from Unit 9 are money damages that we agreed to at the time of contract formation. The buyer and the seller agreed to these amounts. And what we're saying is if the buyer breaches after the due diligence period, the seller will almost always keep the due diligence fee, and they'll get the earnest money. The two equal the seller's liquidated damages. And our contract goes on to say that the seller's liquidated damages are their sole and exclusive remedy, which means if the buyer breaches, the seller only gets the due diligence and the earnest money. They cannot sue the buyer. I think it was last week or maybe earlier this week, I told you guys about my horror story about my buyers that called me 3 hours before closing and said, yeah, we're not coming. Yeah, we're not going to buy this house. They were in breach, weren't they? They were in breach. We were after due diligence. I don't know how to tell you that. I mean, we're 3 hours away from closing. What were their consequences of breach? They lost their due diligence and their earnest money. Question comes in, due diligence fee can't be returned to the buyer even before? No. A fee is generally non-refundable. Think about this. Let's just pretend for a second. What if the due diligence fee was refundable? And I buy your house, or I go under contract to buy your house, and I lock you down for, a couple weeks, whatever. And then I wake up one day and change my mind, and I say, I'm not going to buy your house. Give me my money back. What did the seller get out of that? You just wasted their time, didn't they? So the fee is giving you that free right to terminate. That fee is giving you that free look period. And if you still terminate, well, yeah, you still wasted the seller's time, but at least they got something out of it. At least they got some money out of it. And from the buyer's perspective, the seller can't sue you because you paid for that right to terminate. So buyer breach, the seller's only remedy are the liquidated damages. What if the seller breaches? Man, this buyer can sue the pants off of the seller. They can take you to court for compensatory damages. They could take you to court for specific performance. If they do take you to court for compensatory damages, they could sue you for the due diligence fee, the earnest money deposit, any money you've paid on inspections and investigations. This is about the only time that the seller would ever have to return the due diligence fee is if they breach. This kind of seems one-sided, doesn't it? It seems like the remedies for breach are much harsher for the seller than they are for the buyer, right? The buyer's only going to lose due diligence and earnest money. The seller can be sued. Consequences for breach for the seller are much harsher because the seller is the one that initiated this whole thing to begin with by saying, my house is for sale, bring me an offer. The seller is the one that started this whole process by putting a for sale sign in their front yard. They started this ball rolling. And if the seller decides they don't want to sell after all, or they can't, they are going to suffer more consequences. Again, just introducing you to it. We're going to see this all again in our contract. But no more doom and gloom. All we've been talking about is terminating and breach. What if this thing actually makes it to closing? Sometimes they make it to closing. So what if we actually make it to closing? Well, that due diligence fee and that earnest money that the buyer paid when we went under contract, they're going to get that money credited back to them. So the money they pay up front, if we go to closing, if we make it to closing, that's that much less that they have to bring to closing. They'll get a credit. Does that make us feel a little bit better? A little bit. So the due diligence fee and the earnest money at closing are going to show up as a credit to the buyer. The due diligence fee at closing is going to be a debit to the seller. They've already received that money once when we went under contract. The buyer actually handed them a check when we went under contract. Now that we're at closing, we need to reverse that process. The only time that anybody's going to get due diligence and earnest money actually in their hand is if we don't make it to closing. Whether or not we terminate within the due diligence period or after the due diligence period. We're going to talk about buyers and sellers, debits and credits, what those look like at closing. That's all coming in Unit 21. So we'll talk about debits and credits, who is owed what at closing. That's a lot, you guys, I know. Again, I just wanted to introduce you to some of those terms. We're getting ready to see it again in the contract. We're actually going to go ahead and take our break. And when we come back, we're going to look specifically at our standard offer to purchase and contract. So we'll see this again, defined again in just a bit. So let's take 10. I know we're a little early, but you know, I don't like to start something and not be able to finish it. So let's take 10 and we come back, we'll look at our contract. Do we come back? All right, let's see. Cameras are coming back on. Welcome back. I'm going to take attendance. Make sure your camera's on and I can see you. What we're going to do now that we've just introduced you to some ideas, few things, we're going to go now and see this in action. We're going to see this in play. So our current offer to purchase and contract is on the online learning system. And with the one with the highlights, which is the one we're going to go over, is actually under our Campbell folder. So the online learning system, and wait a minute. There it is. Online learning system, it's under our Campbell folder with our tentative schedule and our PowerPoints. And what I have is a sample offer to purchase and contract. The current one, do not look at the one on your book. The current one is in the online learning system under the Campbell folder. You don't have to ask me. If we're talking about it, is it going to be on the test? If you could see a test question on it, it's in the syllabus. If it's in the syllabus, I've highlighted it for you. So if you see a highlight, we're going to talk about it. And could you see it as a test question? Yes. Please don't ask me if you're going to be tested on this. You're going to notice as we go through this, there's a lot highlighted. The Real Estate Commission thinks you guys should read this to prepare for your test. Now, I'm not going to stand here and read this thing for you. But every single provision is highlighted, you guys. So the commission thinks you should have a good understanding for your state-specific test about the overall offer to purchase and contract. I do think there are some points more important than others, and I will help to pull those out. But guys, every single provision in the contract is highlighted in the syllabus. So what I'm telling you is this entire offer to purchase and contract could be subject for a test question. If you're just coming back from break, please let me know. I see some cameras popping on. I hope I got you. If you're not sure if I got you or not, tell me otherwise. So we're in the Campbell folder, the offer to purchase and contract. We're going to start this today. I'm going to quit about 5-7 minutes early because before we leave today, we need to talk about the midterm, which will be next week. So we're going to talk about that before we leave today so you guys can start getting ready. So we'll talk about that our last couple minutes of class. Obviously, however far we get today is where we'll pick up on Tuesday. So you guys have the weekend to review what we've covered and look ahead if you want. It's of my opinion that this is the most important form that we use in real estate. This is the most important document because this is the document that creates the legally binding contract between the buyer and the seller. And you and I are the ones preparing it on their behalf. Do we have an obligation to understand this thing? Do we have an obligation to know what's in here? You better believe we do. So our offer to purchase and contract, please note, this form serves two purposes. It serves as an offer to purchase and upon acceptance becomes a legally binding contract. So it's our offer to purchase and contract. As mentioned, you do have the guidelines. The first provision is terms and definitions. The first provision is like 2.5 pages long. We spend the first 2.5 pages defining things. If you're not going to do anything else, the minimum is to read these terms and definitions. Here's your vocabulary. Here's your explanation of what things mean. So we first need to define the seller and the buyer. I need all of the names of the sellers and their spouses that have to sign the deed to convey it. I also need all the names of the buyers that are going to be on the deed. Everybody has got to be listed as a seller and a buyer. And we need to spell out everybody's name. Don't put Mr. and Mrs. My name is not Mrs. Ryan Campbell. If you're doing this for a couple, you're going to say Ryan L. Campbell and Julie A. Campbell. We are two different people, two different entities. So we're going to clearly state the names, all of the names. First thing we have to define. Then we define the property. What is the property that the buyer is wanting to buy? Will it include a manufactured home? We need the street address, city, county, zip, state of North Carolina. Remember back in Unit 4, we were talking about legal descriptions? And we said when you're conveying property, the street address alone is not enough. When you're conveying property, we need all of the legal description. So in addition to the street address, city, state, county, we also have a place for the legal description. And we're instructed to complete all applicable. So what's the plat reference? Is it a subdivision? Plat book and page, deed information, tax ID? Again, where do you get all this? You can look it up on the county's GIS. I wouldn't worry about that right now, though. Get licensed first, and then your firm will help point you in all the directions you need to fill in the legal description. So we're going to complete the legal description, fill in as much as we can. If it's not applicable, we're going to put N/A. We're never going to leave a blank blank. Then we need to define the purchase price. And you can see I got a lot going on here. I'll have to minimize this in a minute so we can see everything. But just to go through it first, we're going to start with the purchase price. What is the buyer willing to pay the seller for their home? What is the seller agreed to pay to be paid for their home? From the purchase price, we're going to deduct the due diligence fee. You can see that's blank. That's a negotiable amount. The due diligence fee is made payable and delivered to the seller by the effective date. And we're going to indicate, is it cash, personal check, wire transfer, whatever the parties agree to. We're going to define the due diligence fee on the next page. Right now, we're just putting the amount in. We also need to fill in the amount of the earnest money deposit. We got a place for 2 earnest money deposits. You may see an initial earnest money deposit, which is payable and delivered within 5 days of the effective date. Or we may have an additional earnest money that is payable later. So maybe we're going to negotiate some earnest money's due now, some earnest money's due in 2 weeks or 2 months, whatever. It's all still earnest money. Due diligence is the buyer's right to terminate. Earnest money shows their good faith. For the additional earnest money, here's our time being of the essence, which means it is due on, I need to erase some of this. Time being of the essence means it's due on 5 p.m. on this date. If additional earnest money doesn't come in until 5:01 on that date, time being of the essence says it's late, and the seller may have the right to terminate. So there's our time is of the essence, drop dead date and time. This performance has to happen. We could have a loan assumption. The buyer could assume the seller's loan. We're going to talk about that in financing a little bit. There could be seller financing, which means the seller acts as the lender. Again, we're going to talk about that in financing. If it's new construction, you might have a building deposit. The builder might require a deposit. So all these blanks, and I need to minimize this real quick just so we can kind of see it all together. What we're starting with here, or what we're looking at, we have our purchase price, whatever the buyer and the seller agree that the buyer is going to pay for the home. From the purchase price, we're going to deduct the due diligence, if applicable, the earnest money, any of these deposits, any of these other deposits in this situation. This top blank minus all of these in between give the buyer their final balance. The final balance paid in cash at settlement or through the proceeds of a loan. I've never seen a transaction where every single blank is used. I don't know that that could exist. I mean, I'm sure it could, but typically what we see, for example, we got a purchase price of 100,000, and I'm just making numbers up. Buyer and seller agree to 500 in due diligence. Buyer and seller agree to 1,000 in initial earnest money. Buyer and seller agree to 1,000 additional earnest money. So when we take that 100,000, the buyer now has a new balance of $97,500. They've prepaid that money, and now what they're responsible to bring to closing is the purchase price minus those fees and deposits, everything in between. So defining not only the purchase price, but also defining the fee and the deposit amounts. Questions just on this piece? Will this form be on the midterm? You may have some questions. Yeah, you may. It's unit 10. Again, we're talking about the midterm before we leave today. Do we NA all others? Yep. Thank you for catching that. So if this isn't, or what you could even do, right, is just put 0. So one or the other, right? One way we're indicating that there's no monies as part of that. Thank you. Okay. So we're just defining the purchase price, how much the buyer's willing to pay. The parties have got to agree to the due diligence fee and the earnest money. There is no set amount. There is no formula. Sometimes new agents, sometimes you guys try so hard to work for a formula. Well, if the purchase price is this much, then that means the buyer has to pay that much, and it's completely negotiable. Anybody try to buy a house in the last 3 years, 2 or 3 years? Due diligence and earnest money amounts were absurd. I'm not kidding when I'm telling you I've heard of 6-digit due diligence and or earnest money deposit amounts. Guess what? We're coming out of that market, and we're starting to see due diligence and earnest money come down. A lot of it is dependent on the market, the conditions, what's going on today. It's completely negotiable. Make it big again where we can see it. Just real quick, at the bottom of page 1, I think we saw this in our agency agreements, but just in case. This is a realtor form. You got to be a realtor to use this form, evidented by our capital R for our realtors. The form is jointly approved by the North Carolina Association of Realtors and the North Carolina Bar Association. North Carolina Bar Association is our attorneys. So this form was drafted and created by attorneys and the North Carolina Real Estate Commission. Due diligence fee will go to the selling price if we go to closing. Let me say when we get to closing. We have an equal housing opportunity, and then it tells us what form we're using, and make sure you're using the most current form, which was last July. Don't know if there's any changes going to come this year or not, but it's possible. Over on page 2, we actually define some words. I'm not sure what it is, Laura. If you can share that in the chat. All right, so we're actually going to define some things starting on page 2. First off, again, I think you guys should read this because it explains, it defines what the earnest money deposit is. The earnest money deposit shall be deposited and held in escrow by an escrow agent until closing, at which time it will be credited to the buyer, or until this contract is terminated. So the whole point of the earnest money deposit, again, we're showing the buyer's good faith, and we're going to let an impartial third party known as the escrow agent hold it. The seller's not going to touch it. The buyer's not going to touch it. We're going to let this impartial third party of the escrow agent just hold it for safekeeping, either until we get to closing or this contract's terminated. If this offer is not accepted, the buyer doesn't owe earnest money. Please understand, the buyer doesn't owe any money until and if a contract is formed. So if the offer never becomes a contract, they don't owe. Let's see, I understand, thank you. So back up here, question about the capital R. Can our firm be realtors, or do we as individual agent? If your firm is an NAR member, then you will have to join as well. So if you join a firm that's not a member of NAR, then you don't have to. But yeah, if your firm's a member of NAR, then you'll have to join as well, part of it. Thank you. Okay, so earnest money held by an escrow agent, then we need to find the escrow agent. First off, we're going to insert the name of the firm that's acting as the escrow agent. In residential sales, typically we're going to have the closing attorney hold the earnest money deposit. Now, some real estate firms do have an escrow account. And if the firm has an account, then the real estate firm can hold it. But in residential sales, we're seeing more and more that we're just letting the attorney do it. Guys, the escrow account, there's a big liability there. And a lot of firms are starting to do away with it. We're going to talk about the escrow account when we get to our license law and commission rule. You guys are going to read about it in the comments before we get there. So we'll have that discussion. But right now we need to know that there's a firm acting as the escrow agent that's going to hold the earnest money deposit. And we need to be able to identify who that escrow agent is, who the firm is, so we know where that money is. This blue note talks about a dispute over the earnest money deposit. I'm not going to get into this now. You're welcome to read it now. But again, we're going to talk more about that when we get to license law and commission rule. Just trying to ease you in. Bottom line, if we terminate, what happens to the earnest money deposit isn't automatic. The parties have to agree to release it. And if they don't release it, it's in dispute. And this addresses what happens to that disputed fund. So more on that. Typically the buyer's attorney, yes, typically the buyer's attorney, but we could, because they're going to act as the closing agent, as a closing attorney. Yep. But remember, this is completely negotiable. So if we want the seller's attorney to hold it, could they? Absolutely. If we want the real estate firm, the only requirement is they have to have an escrow account. They have to have a trust account. More on that. Then we define the effective date. This is defining that magic moment in time that it goes from being an offer to a contract. So the effective date in our contract is defined as the date that, number one, the last one has signed the offer or the counteroffer, and number two, such signing or initiating is communicated to the party making the offer. So the effective date is that magic moment in time when it goes from being an offer to a contract. And I need two things: the last offeree to accept, and communication of acceptance, crossing the line, going back to the party that made the offer. Typically, these two things happen on the same day. We get this done on the same day. But what if, let's say, what if you're negotiating late at night and you get the signed acceptance at, I don't know, 11:35 p.m. But you don't send communication until 6:30 a.m. the next day. The effective date is going to be the next day because I need both pieces. I need both steps. So if you sign today, but don't communicate until tomorrow, the effective date will be tomorrow. We must have both pieces. Questions on that? Then we define what due diligence is. Due diligence is the buyer's opportunity to investigate the property to decide whether the buyer, in the buyer's sole discretion, will proceed with or terminate the transaction. Due diligence is their opportunity to learn as much as they possibly can and decide if they want to buy this home or not. The due diligence fee is defined as a negotiated amount, if any, paid by the buyer to the seller for the buyer's right to terminate for any reason or no reason during their due diligence period. The buyer is paying the seller for the right to terminate. And if they terminate, they've exercised that right. That's what they paid for. Again, what I'm telling you is, if the buyer terminates within the due diligence period, the seller can't go after them in court. They can't attempt to collect any more money. They can't go after them for pain or suffering or anything. The buyer paid for that right to terminate for any reason or no reason. The due diligence fee becomes property of the seller upon the effective date, and it's going to be a buyer to the credit to the buyer if we make it to closing. The due diligence fee is non-refundable, except in the event of seller breach. So if the buyer terminates, guys, they can't terminate and get their money back. What does the seller get out of that? Nothing. So if they terminate, they've exercised that right to terminate, the seller keeps it, unless the seller breaches, the seller can't perform. Then we define the due diligence period. Due diligence period begins on the effective date and goes through 5 p.m. on whatever date, time being of the essence. The buyer can terminate at any point from the effective date through 5 p.m. That's pretty specific, isn't it? 5 p.m. on whatever date we agree. If they terminate within this time, they'll get their earnest money back. If they terminate at 5:01 on this date, now the buyer's in breach. Time being of the essence is our drop dead date and time. Questions on due diligence fee, or the due diligence period? You also got this in your book on 289. By the way, I'm sorry, I forgot. Look with me on your book on page 287. (287) to 293 also talks about these provisions from the contract. So you can look at the contract. You can also look at page 289 that also explains due diligence fee, and due diligence period. You guys see that? So those pages, what I just say, 287 to 293 correlate with some of the provisions. I would say the more important provisions of the contract. So we defined our due diligence period. This is one date that we have to agree on. It's blank because we got to negotiate. We got to agree on it. Then we got to define settlement and closing. I have a confession to make. You guys want my confession? I, as a real estate agent or as a buyer of 2 properties, I've never in my entire life attended closing. What we actually attend, what we actually participate in is something referred to as settlement. Settlement and closing are 2 different things. Now, once you get out in the real world, you're going to call it all closing. We all do it, every single one of us, and you will too, I promise. For your exams, we need to know there's a difference. There's settlement and there is closing. Settlement is when we go to the attorney's office with our buyers or sellers. The attorney gathers all the documents that they need from the buyers and sellers. They get everybody's signatures. The buyer probably has to bring funds. So the buyer will wire transfer in their closing funds. If your seller's underwater, they'll have to bring money as well. So settlement is when we go to the attorney's office and the attorney gets the paperwork and the monies from the parties that they need to proceed. We're going to agree on a settlement date. Shortly after we go under contract, we need to call the attorney and get that scheduled. We'll talk about that contract to closing process. We're getting there. Once we all leave the attorney's office, then the attorney proceeds with closing. Closing is defined as the completion of the legal process. Closing consists of settlement, which we defined, satisfactory title update. We talked about title insurance back in Unit 5. The closing attorney's receipt to disperse all necessary funds. We got lots of people standing in line with their money, with their hand out, waiting on their money. And then the very last act, the very last thing to happen is that we're going to record the deed in that county's register of deeds. The very last thing to happen is the attorney records the deed. Then and only then is it a done deal. So let me back up. We go to settlement. We go with our buyers and sellers. Why not? We've been with them from day one anyway. Why not finish it out? Go with them to settlement. The attorneys get their signatures. They get their monies, whatever they need. Then we all leave the attorney's office and the attorney proceeds with putting the finishing touches on everything and recording the buyer's new deed. Only after the deed is recorded should the buyer get access to the property. Only after the deed is recorded is when you and I get paid. All those people standing in line, which at this point you and I are in line now too, wanting our commission. Then and only then will they release checks. It's done. Congratulations, Mr. Buyer. You're now a homeowner. Here's the keys to your new home. Best of luck to you. Questions on that? Settlement versus closing. 2 different things. Again, in the real world, you'll call it all closing. For your tests, you need to see there's a difference. Yeah, or you can watch the recording. Yep, I'll have that up shortly. Yep. Okay, so question comes in. We don't actually go into the office for closing. Nah, I've never been to closing. I have no idea what well, I know because the contract tells me what the attorney does. What we attend is settlement. Once we leave, that's when the attorney finishes up with closing. Two different things, two different distinctions, again, for your tests. There is a difference. Big red warning. This just reminds us that we have to use an attorney. North Carolina is an attorney closed state. Not all states use closing attorneys. We'll talk more about that when we get into Unit 21. But North Carolina is an attorney closed state. Why I think this is important is if you're working with a buyer from another state, because if you're working with a buyer from another state, they may come in and look at you and say, do I have to hire an attorney? Because that's not how they do things in their state. The answer is, if you're purchasing a home located in the state of North Carolina, yes, you have to hire an attorney. We are an attorney closed state. And then the last thing we're defining in that first provision, terms and definitions, are our special assessments. Right now, we're just defining what it is. As we get further into our contract, we're going to see who's responsible for the special assessments. Is the buyer responsible? Is the seller responsible? So we'll break that down further. Again, you guys, I'm going to go back up just for 1 second. I just spent 2.5 pages, the first 2.5 pages of our contract, defining terms and definitions. If you don't want to do anything else with this contract, I can't make you read the whole thing, but if you don't want to do anything else, please at least look at the terms and definitions. Due diligence fee, due diligence period, earnest money, they're going to be on your test. So here's another resource, the resource. I mean, this is straight from the horse's mouth right here. This is the resource for the due diligence, earnest money, purchase price, closing, settlement, etc. Questions? I asked a little bit ago where my homeowners are on the call, and you don't have to raise your hand right now because now I got a rhetorical question for my homeowners. When you bought your home, did you read the contract before you signed it? Rhetorical question, you don't have to answer that. Again, you guys, buyers and sellers, for the most part, are not reading these things. That's why they're relying on us to explain what due diligence means, to explain what earnest money means, to explain what the settlement date, closing date. That's why they hire us. Second provision is our fixtures. We saw this exact same provision, word for word, in our listing agreement. So we have the specific things that are considered fixtures. If we're using the standard offer to purchase and contract, these things are considered fixtures. If you're using a different contract, the fixture list may look different. So this is just for our standard contract, identifies things that are fixtures. If the seller's going to take any of these things, then we need to specify them here. The following shall not convey. Now, if they take them down before we list and the buyer never sees them, then I don't have anything to put in here. But if the seller doesn't take them down, if the buyer sees them, then we need to make sure that it's excluded. So the buyer knows when they buy that these things are not going to be here. We're also told that the seller needs to repair any damage caused by the removal of any of these fixtures. So the seller just can't jerk the ceiling fan out of the ceiling and leave a big hole in the ceiling. They need to repair the damage caused by removing that ceiling fan. So if they take a fixture, they need to fix what they leave behind. We also have the third provision on personal property. Please remember, a fixture's Intention is to stay. Personal property is meant to go. If either one of them are going to do the opposite of their intent, we need to spell it out in the offer to purchase and contract. Remember the parole evidence rule? Remember the refrigerator? If the refrigerator is not listed here, the seller is not legally obligated to leave the refrigerator, even if it was all in your previous negotiations and your MLS advertising and you had a conversation about it and everything. If it's not listed here, and guys, when you're listing personal property here, please be specific. Don't just say the refrigerator. There have been stories. Buyer and seller agree that the seller is going to leave the fridge. Buyer shows up at closing, or I'm sorry, buyer shows up after closing. They got their brand new keys to their brand new home. They walk in the front door, and in the kitchen where the refrigerator that was there should be, instead the sellers leave a 2-shelf dorm room fridge. Did they do what they were contractually obligated to do? Did they leave a fridge? Be specific. Tell that your buyers want the 2-door stainless steel Whirlpool refrigerator. Take a picture of it. If you can get a make or a model number, even better. Don't just put fridge, because what is the seller legally obligated to leave? Any refrigerated item. What if you got a refrigerator in the kitchen and one in the garage? If you don't specify which fridge, so be clear when you're asked, especially as a buyer's agent, when you're asking for personal property as the listing agent, make sure any fixtures that your seller wants to take. Be clear. Questions on that? People get petty, y'all. Petty. Continuing right along. Provisions 4, 5, and 6. 4, 5, and 6. I did that. 4, 5, and 6 are all about the buyer. 4, 5, and 6 are specific to the buyer. So if you're a buyer's agent, 4, 5, and 6 are the ones you kind of want to point out to them, the ones that you want to make sure you have that discussion with. Provision 4 is about the buyer's due diligence process, and it starts with a big red warning. Buyer is strongly encouraged to conduct due diligence during their due diligence period. If the buyer's not satisfied with the results, the buyer, give a highlight, should terminate this contract prior to the expiration of the due diligence period. If they're not happy with what they're learning, if their investigations and inspections are turning up a whole bunch of stuff, the buyer should terminate prior to the expiration of the due diligence period. Nobody likes to terminate. Let's put this out there. Nobody likes to terminate. But as a buyer's agent, if we have to terminate, the best thing I can do for my buyer is to terminate within due diligence. So at least I can get their earnest money back. So shortly after going under contract, we start our inspections, our investigations. We're going to help the buyer learn about the property so they can decide before due diligence is over if they want to terminate or not. The buyer may ask for a written extension. We can ask for extension to due diligence. Do you think the seller has to grant an extension to due diligence? Do you think they have to? No. We can ask for more time. There's no law that says we can't ask. But the seller's not obligated to grant an extension. Buyer continues to investigate after due diligence. The buyer hasn't learned everything about the property. They've learned a lot after due diligence or before due diligence, but they haven't learned everything. Understand what they're giving up with due diligence is the right to terminate. they're not giving up their right to investigate and learn about the property. So they can keep investigating up until the day of settlement. We're going to talk about something called a final walkthrough. They're still learning about the property up until the day of settlement. Understand, with due diligence being over, all they're giving up is waiver of their right to terminate and to get their due diligence feedback. As part of the buyer's due diligence, we're going to recommend that the buyer do certain things. So the rest of this provision is just kind of a suggestion of things that the buyer should do during due diligence, so they can decide if they want to proceed with or terminate. If they're getting a loan, we need to get them started on loan approval. We go under contract as the buyer's agent. One of the first things you're going to do is send this information to the lender so they can start their process. The lending process is the longest process of the contract to closing. So we got to get the lender started on their thing early. Lender units are coming next week. We'll talk about the loan process. We're reminded that there are no loan contingencies. We talked about a contingency because we need to know what that word means. There are no loan contingencies. Can the parties agree to add a contingency? Of course, the parties can agree to anything, but there are no built-in contingencies in our contract. Then the buyer's given a list of things that they're encouraged to investigate while we're still in due diligence. This isn't a must. This isn't a complete list. This is just to help the buyer know what they should consider investigating and inspecting. We're going to talk contract to closing process is unit 21. So we're just going to briefly, some of this stuff we've already talked about. So buyer will get both due diligence and earnest money back if they terminate during due diligence. That is not correct. If the buyer terminates within due diligence, they only get their earnest money back. Remember, fees are generally not refundable. So have conversations with your buyer. You're under contract, you tell your buyer to investigate the property and they say, well, where do I start? Well, you can have some inspections. You can have a home inspection, a pest inspection, a radon test. If it was built prior to 1978, maybe we have the lead tested, right? We can't make them do anything. We're just making recommendations. Reviewing the documents. If it's in an HOA, we're going to help them get those covenants, the bylaws, the information about the HOA. Homeowners insurance, we got to get that secured while we're in due diligence. The appraisal, talking about both of these later. Survey, we talked about in unit 4. Zoning, flood hazard, utilities, streets. Back from unit 6, we talked about streets and roads. I know I'm going through this fast, but one of the highlights here. Special assessments. Again, and the reason why I'm going fast now is because I'm going to spend more time with it in 21. What I need us to understand is this contract just gives the buyer an idea of things that they should investigate, an idea of the things that they should consider having inspected. Generally speaking, you guys, the home inspection is not required. But why in the world would a buyer not want to have a home inspection, especially when they get this free look period? Also, as I just said, this list is not inclusive, which means if your buyer wants to investigate something that's not on this list, as their agent, our answer is okie doke, we'll do it. This just gives them an idea of where to get started. If the buyer has to sell or lease an existing property, again, this is not a built-in contingency. We're just letting the buyer know that if they have to buy or sell It's not conditioned upon the sale or the lease. If they do have to buy or sell to qualify for a new loan, they should seek to close prior to the end of their due diligence period. If at all possible, it will be reasonably sure. Because if the buyer doesn't buy their home, then that buyer can't buy the one you're under contract with. So we're just having that conversation. Repairs and negotiations, I think so. Repair negotiations. Remember we said all properties in North Carolina are sold as is? Here it is. Unless the parties agree otherwise, the property is being sold in its current condition. Is the seller required to do any repairs? No. Can we ask the seller to do repairs? Yeah. But the seller has every right to say no. If the seller agrees to do any repairs, anything, I'm talking change a light bulb. If the seller agrees to do anything, we've amended our contract. We have changed it because what's that one very important sentence say? This property is being sold in its current condition. I have an amendment. We do have a form that we can use if the seller does agree to do any repairs. We'll get into a little bit more on that. Buyers advised to make any requests in sufficient time to allow negotiations for these requests to be conducted prior to the expiration of the due diligence period. Remember what we said, it's their free look period. Now knowing what I know, do I want to move forward with or terminate this contract? So if the buyer asks the seller to do a lot of repairs or any repair, and the seller says, no, I'm not fixing anything, I'm not going to change a light bulb, I'm not going to do it. The buyer is now deciding, now knowing what I know, do I want to move forward with or terminate this transaction? And if the seller is going to do any repairs, we have to have it agreed upon and in writing while we're still in due diligence. Questions on that? We mentioned this earlier, buyer's obligation to repair damages. If the buyer's home inspector damages the property, it is at the buyer's expense. This repair obligation survives termination of the contract. So if the buyer's home inspector damages the property and then the buyer terminates, the buyer's still on the hook to fix it. Can the buyer go after the home inspector in a court of law if they damage the property? I don't know. I'm not an attorney. But I'm guessing that the home inspector is going to make the buyer sign something that says, you can't come after me in a court of law. Home inspectors have attorneys too. Question comes in for seller breach, specific performance. If they go after specific performance, if the buyer goes after specific performance, they're not going after money. If the buyer goes after specific performance, they're trying to make the seller sell. They're trying to make the seller perform. And then we have, real quick, buyer's right to terminate. Buyers shall have the right to terminate this contract. Here's again, for any reason or no reason. During the due diligence period, time being of the essence. If the buyer timely terminates, the earnest money deposit shall be refunded to the buyer. Does that say they're going to get their due diligence back? It says they're going to get their earnest money. So again, as a buyer's agent, nobody wants to terminate. But as a buyer's agent, if we have to terminate, if your buyer's not satisfied with this home after the home inspection or after they learn about it, the best thing we can do as a buyer's agent is to terminate while we're in due diligence so we can get the earnest money back. Last piece of this says closing shall constitute acceptance of the property in its then existing condition unless provisions otherwise made in writing. So once that deed is recorded, congratulations, Mr. and Mrs. Buyer. This house and all of its problems are now yours. Guys, there is no returns. There are no refunds. There are no takebacks, which is why we give this buyer this opportunity to learn, to find out the problems, because once that deed changes hands, they're stuck. It's theirs. Questions on the first 4 provisions? You guys can look over this weekend. This is kind of good that we're breaking this down. We're just on page, where are we? We're on page 6. So just the first 4 provisions. If you want to ease into it, you're welcome to look at the rest. It's all right here. We'll talk about it next week when we come back. Together. We do have to go through this form, and I see some of you guys glazing over, and I understand forms aren't the most exciting things in the whole wide world, but guess what we use as real estate agents? Forms. What are you going to be tested on in about a month? Forms. I can't make this important to you. All I can do is try to encourage, I can try to convince you guys the importance of this form. I do encourage you guys to look it over. Is that fair? When we come back together on Tuesday, don't go anywhere just yet. We'll pick up here with buyer representation. We'll finish talking about our offer to purchase and contract. And then we'll finish unit 10. Really, the star of unit 10 is the offer to purchase and contract. So we don't have too much more else to say, but we do have a few more things left to talk about. So we'll have those conversations on Tuesday. All right, so what I want to talk about right now is the midterm. Guys, remember from the first day of class, we said you need 3 things to successfully complete this class. You need to meet the attendance requirement. You need to pass the end of class exam. And you need to attempt the midterm. The midterm is mandatory. What does the word mandatory mean? If you don't do the midterm, you're not eligible for the end of class exam. Did everybody just hear what I said? I think we get selective hearing sometimes. If you don't attempt the midterm, I'm not looking for pass or fail on the midterm. I'm looking that you tried it. I'm looking that you attempt. Guys, the midterm is not for me. The midterm is not for Lane. The midterm is for you. The midterm is meant to serve as a gauge on where you are at this moment in time. The midterm will cover units 2 through 10 and 20. 20 is our environmental unit. Y'all remember that super scary unit? So don't worry about 1. Don't worry about 1. The midterm will cover units 2 through 10 and 20. I'm not going to do the midterm in class. We don't have time. So what I'm going to do next Tuesday, I'm going to release the link for the midterm for you guys, and I'm going to give you an entire week to complete it. It's about 2 hours. Maybe it'll take you that long. Maybe it won't. You guys get a week to give me 2 hours. Is that fair? Mandatory. When you finish the midterm, and again, we'll talk more about this on Tuesday because I'm not releasing the link until Tuesday. Do not email me this weekend and say, Julie, can I go ahead and have the link? I'm going to tell you now the answer to that is no, because I got to finish unit 10 before I can release the link. So next Tuesday after class, I'll release the link. I'll show you where you can find it. You'll have a whole week to complete it. When you finish the midterm, you're going to get a report. You're not going to see the questions again because you're never going to see those questions again. So studying what you missed isn't going to help you. What is going to help you is the report. And the report breaks it down into sections. It tells you how many did you miss from unit 6? How many did you miss from unit 8? How many did you miss from unit 10? It breaks it down into different sections. So if you bomb unit 6, the individual question doesn't matter. If you fail unit 6 in the midterm, the report is going to show you that and hopefully encourage you to go back through unit 6. Does this make sense? We're serving it as a gauge. If I were you guys, I would treat the midterm as if you were sitting down taking the final exam. If you were treating this like a real test, if you took this test next week, would you pass this final exam? So Tuesday after class, I'm going to release the link. I'll give you a week. I need everybody to take it because it's mandatory. You and I will both get a report. You'll get a report and I'll get your score too. Your scores are confidential. I'm not going to share them with anybody. Again, it's not for me, you guys. It's for you. And I hope you guys will use this to your benefit. The other thing about the midterm, it's in the same platform that our final exam is on. So it gives you practice with that vehicle. So you're not seeing it for the first time on test day. Isn't that nice? So we're giving you that exposure to the platform before test day. So I got a couple questions coming in. Let me grab these real quick. Can you take it more than once for practice? No, thank you. The midterm, it's one deal. So when you sit down to take it, make sure you have those 2 hours set aside. If you feel like you could be interrupted or you can't finish it, then don't start it. Dedicate 2 hours to the midterm. It's a one shot. Midterm is everything until unit 10. The midterm will consist of units 2 through 10 and 20. What we've covered so far, 2 through 10 and 20. How many questions is it? 54, 56, give or take. There's no math on the midterm. You won't have any math. What if you're not in class on Tuesday and how do you get the link? Well, if you want to watch the video, I'll show you where the link is. If you don't want to watch the video, you just reach out to me after class on Tuesday and ask me where the video is. I'm sorry, where the link is, not the video, the link. I will show you guys on Tuesday where you can access that link. So you can take it at any time from next Tuesday to the following Monday. You get a week. So why do I tell you all this right now? So you can spend this weekend reviewing. What a great opportunity to review what we've covered so you can get yourself ready for that midterm. So next week, we'll release the midterm. We'll finish up unit 10. The other thing that happens next week is we start financing. So for those of you looking ahead, we're going to start on units 14 and 15. We're actually going to put lender hats on. Did you guys know you got to play the role of a lender in pre-licensing? We get to put lender hats on. So for those of you looking ahead, I encourage you to. Once we're done with 10, we're heading to units 14 and 15. Question comes in, can you take the midterm again before the final? No, it's a one-time link. Don't worry, I got comprehensive exams for you guys once we get to the end. This is just the first half. So when we get to the end, I got more for you, never fear. Other questions? Review this weekend, get ready for that midterm. Never hesitate to reach out to me. If I can help in any way, let me know. But you guys have a great weekend. Study and play hard. And we'll see you guys Tuesday at 9 a.m.